Right. May we have an appearance of counsel, please, or call the case, please?
Calling case 15 Civil 61004 Zolch, Stone versus Genden et al.
May I have appearance of counsel, please? I hear we had some defense lawyers hiding in the back that we couldn't find for a moment. All right, appearance of counsel, plaintiff first, please.
Oh, yes, sure. Candice Schwager for the plaintiff, Barbara Stone.
Hey, good morning.
Good morning.
David Glantz representing Judge Genden.
Okay.
Good morning, Your Honor. Roy R. Lustig, pro se, and for Blair Lapidus, guardian of the person and property of Helen.
Good morning. All right, we're here today for a hearing on the plaintiff's style as a motion for a temporary restraining order. We've treated it as a motion for preliminary injunction and set it down for hearing today. Before you proceed, Ms. Schwager, I want to ask you something. As I said, we treated this as a preliminary injunction. We've been pretty flexible. I've been pretty flexible with allowing you to not fully comply with the rules, and I have no problem with that. We're going to let you do whatever you need to do here today. One thing that's a significant concern to me, though, and I'd like you to address it, and something that was brought up, I guess, in Mr. Lustig's pleading. In the complaint, you represent that there was a hearing in front of Judge Perlman in Broward Circuit Court, and that she stated on the record that she, quote, did not believe a word Lustig said. You cited to the transcript. In fact, in the complaint, I think you referred to it as being crucial to your case. And I've read the transcript, and that's not at all what Judge Perlman said. In fact, she said essentially the opposite of that. She said, there's no evidence in front of me to make that finding. I can't just willy-nilly say, oh, all of these tests are going to be done. I believe everything you say, Ms. Stone. I don't believe anything you say, Mr. Lustig. It doesn't work like that. In order for me to make a ruling, I need evidence. Essentially, she's saying the opposite of what you say she said in the complaint, and you said it's crucial. So I want you to address that, because I take misrepresentation very seriously. Failing to comply with local rules, I also take seriously, but I allow some flexibility. I don't think you're from here. You do have local counsel who should be taking care of that for you, but tell me about that, what appears to be a clear misrepresentation in a pleading in federal court.
Yes, sir. I first of all apologize that for the oversight.
I'm sorry,
Let me ask you too. For all of you,
Okay.
I'm not very formal in here. You don't have to stand at the podium. You don't have
I'm
to
sorry.
stand to speak.
Yes.
You do not.
No? Okay, I'm sorry.
But you do have to speak into the microphone that's being recorded. I understand we also have a court reporter. Is that right? Okay. But please speak. If stand or sit at your pleasure, but please speak into a microphone.
Thank you, Your Honor. First of all, I present to you that there was no intentional misrepresentation at all. It was an emergency pleading, and when I read the transcript, I suppose I didn't catch the way that it was phrased. I saw probably the two lines in the middle of that page, and I put together the sentence, and I don't know if my mind drifted, but my witnesses felt like that's what they heard in the hearing. And I know you don't always hear every word the judge says, but that was, when we went through the evidence, that was the feedback that I was given. Was they felt like the judge had said that, and it was a very strong indictment of Mr. Lustig. And so when I read his motion, I agree with you that it is, when you read the whole entire passage together, you can tell that maybe there's an emphasis. The emphasis is a bit different.
It's more than the emphasis. First of all, you didn't cite to what your witnesses thought they heard in court. You cited to a transcript. And it's not anything that's subject to interpretation. And I'll read it again. The only thing I'm reading out is Ms. Stone saying, yes, Your Honor, and I understand. She says, I can't just willy-nilly say, oh, all these tests are going to be done. I believe everything you say, Ms. Stone. I don't believe anything you say, Mr. Lustig. It doesn't work like that. In order for me to make a ruling, I need evidence. I don't see how you can read that transcript as opposed to hearing a report from someone who is in court. I don't see how you can read that transcript and seeing it as anything other than it is, which is a judge saying, I can't say these things. And then to represent that to me as this is what the judge said. It's clear misrepresentation to me.
I definitely wouldn't intentionally do that, Your Honor. When I read it, I read it as an isolated sentence on the page, and I didn't thoroughly read it. So I can admit that like I said, it was a surprise to me when I saw his pleading, because that's not the way I interpreted it, and I was probably I went through it too quickly, because I had so much to go through, and it was emergency pleading. So I apologize if I was, a bit negligent in not ensuring that was completely accurate.
All right, I'm not going to make any finding about that here in court. I just wanted to bring that to your attention. And again, that's the kind of thing that I take very, very seriously. So
I understand.
let's leave that aside for now. We're here for hearing on your motion for a TRO, which has been interpreted, because you didn't follow the rules for TRO. We've interpreted it as a request for a preliminary injunction. Let me remind you what we're here for and what we're not here for. In order to obtain a preliminary injunction, you have to demonstrate, 1, a substantial likelihood of success on the merits, 2, that irreparable injury will be suffered if the relief is not granted, 3, that the threatened injury outweighs the harm the relief would inflict on the non-movement, and 4, that the entry of the relief would serve the public interest. So it's extraordinary relief you are requesting. It's a heavy standard that you have to meet, and you're up.
Thank you, sir.
Okay.
If I may briefly start with a summary of kind of what we come here today to present. I was thinking about this, and I can't think of anything more stressful than watching a parent who's ill pretty much die or almost die, except for watching a parent get very ill, almost die, and be arrested and prosecuted for interfering or allegedly interfering.
Incidentally, before you go forward, is that Ms. Stone next to you, or is this another attorney, or
Yes,
sir.
sit back there.
Yes, sir.
who's this?
I'm Barbara Stone.
Barbara Stone.
Okay.
Thank
All
you.
right.
Okay.
Well, the record show that Ms. Stone is sitting at council table now.
Thank you, sir. I've worked with the disabled and special needs children for 15 years, and I've quite frankly never seen civil rights violations that I've seen in this case. I'm not asking you to review a guardianship as a guardianship appeal. I'm not bringing these issues to you in the sense that they are in a guardianship case. I'm bringing it to you as a civil rights case. And incidentally, the proof that I have to submit, it concerns Barbara, and it also concerns your mother, but it's necessary to demonstrate that the orders that were issued against her were invalid or void, and many of the orders were dependent upon the next order. So, a show cause order would be, would flow into the writ of the writ of attachment. And so if one was invalid, all of them would end up invalid.
All right, I'll allow you some leeway in order to give me background, but let me let both
Okay.
parties know that I've read everything that's been filed in the case. By that I mean, with respect to this particular issue, I've also read the pleadings and the motion
Thank you.
to dismiss, but that's not before me today. But I've read all the pleadings, so you don't have to educate me about the entire background, and I'm not going to allow educating me about the entire background swallow up the purpose that we're here for today. So I'll give you a little bit of leeway about giving me background, but I'm going to bring you back, I
Thank
suspect,
you.
over and over again to the issue that we're here for, which is you're essentially asking me to enjoin Judge Genden from running his courtroom.
Sure, thank you. One key aspect of the case is, throughout the case, there's a lack of due process. If there's one defining characteristic, it would be that when the state doesn't follow its own procedures for guardianship or whatever it might be, there's of course there's a denial, and that's what this case is about. I have several witnesses here. Dr. Robert Sarhan, he'll testify about the pattern and practice that he's observed of the same conduct and the same abusive orders and retaliation. That in 12 years that he's been involved in this area, his mother's also incidentally a victim, but he's pretty much an expert if there was one. Deborah Rockland is a probate lawyer. She's here to talk about her conversation with Judge Genden and subsequent events that followed as a result of her attempting to help Barbara's mother. This guardianship, the problem with this guardianship is that the guardianship itself was a complete denial of due process, and it was void from the outset. The medical reports used they didn't follow their own procedures. There was 50% of the requested information was missing. They didn't even actually, on some of them, diagnose her mother as incapacitated, and yet they took away all the rights. And so it's about deprivation of rights. Patty Reed is a witness who worked at the healthcare facility where Helen Stone is held, and she will testify that she's held against her will and that she's not happy there and wants to leave. And the importance of that fact is that one of the key attacks made against my client in this action is that she did something wrong when she attempted to remove her mother from a harmful situation where she felt she was going to die. And actually, under Florida law, the defense to the charge of interference with custody of an incapacitated person is that you perceive them to be in a dangerous situation and are attempting to intervene as a good Samaritan or help them. So, as I mentioned, there's a series of illegal orders. The client was arrested 3 times and faces arrest imminently, as we mentioned, if relief isn't granted. And, Barbara ultimately learned in seeking to find protection for her mother that the more she sought for protection, the more retaliation. We have a Rabbi Barber who would like to testify. We just received notice yesterday, I believe. He was in North Carolina, unfortunately, and so I wanted to ask whether you would permit us to have him testify by phone.
What is the rabbi going to testify about that's relevant to the specific issue that's before me, which is not reopening a guardianship? We're not doing that.
Well,
It's an issue of whether I'm going to enjoin Judge Genden.
The issue is credibility, because consistently Mr. Lustig attacks Barbara Stone's credibility. I mean, his argument is that, well, she's not succeeded yet, so this must be frivolous too. And that's not even a causally related logical argument, but it's at every juncture is an attack on Barbara Stone instead of what the case was about in the first place. And the reason for that is that the whole case, throughout the whole case and the orders that we are seeking for you to review and enjoin are retaliatory. They're illegal orders. I mean, there's actually one order that says no jury trial. And they're deprivation of rights, which is a 1983 cause of action, which is what we've pled.
What's a rabbi going to tell me about the deprivation of rights by not giving a jury trial?
He would like to talk about, we're not asking you to assess the credibility of witnesses who want to testify about what they saw, about neglect. What we're asking, and the point we were attempting to make in all this is that reports were made, and 3 witnesses have made reports, and yet no investigation, not so much as investigation. It seems to be a problem that Barbara's primary requests were for her mother's constitutional rights to be honored, for an attorney, for a doctor, to testify, to be able to come to court. None of them were honored, and it's a pervasive pattern and a practice of depriving both the elderly and disabled and their relatives who are advocating for them of their civil rights. Rabbi Farber he made, I think, 4 reports, and Mr. Lustig wrote him and said that at that point you're barred from visiting. You can't come anymore.
Right.
It's a deprivation of the right to free exercise.
All right, let me interrupt you. We have a limited amount of time. I'm going to allow you to present what you need to present, but if you're going to use that time presenting things that I don't find to be relevant to the issue before me, that's on you. How long do you anticipate, whatever witnesses you have here today, how long do you anticipate all of them taking?
I could keep them at 20 minutes or less if that's not too
Altogether?
much. I'm sorry?
Altogether?
Well, some of them may be longer.
Are you saying 20 minutes each
How
or 20
long,
minutes
are
altogether?
you talking about total time?
Yes.
If we could have about 3 hours, that would be very helpful. I don't know that I'll take it, but the other side may use quite a bit of that time, I don't know.
I'm not going to give you that time if it's going to be witnesses who are going to come in here and tell me about the condition of Ms. Stone's mother or the condition of the facility that she's in or anything that has nothing to do with what's in front of me. So I'll give you a reasonable leeway with what you can present, but no, don't take 3 hours presenting witnesses to me that don't address the issue of whether you are likely to succeed on the merits of your case, whether there's irreparable harm, and we aren't talking about the underlying case, we're talking about the validity of Judge Judge Genden's orders and his ability to proceed. So,
Yes, sir. And I just wanted to say one thing. The validity of the orders is, it really intersects with the credibility of these witnesses, and Ms. Stone particularly. And so that's my only concern, is that there is evidence and there were procedures that were supposed to be followed, and they were denied at every point.
all right, well, let's stop talking about it, let's get to it, but I'm going to limit you in time. You're not going to have 3 hours to present evidence that really doesn't have anything to do with what is before me. We're going to wrap this up this morning. Let me just ask briefly, what's the position of defense counsel, Mr. Glantz?
On the motion for preliminary?
No, we'll hear argument later, but I'm going to allow her to have some leeway. Do you have any objection to? I guess the immediate question before me is, will I permit testimony by phone because the rabbi's not here?
Yes, sir.
Any objection to that?
I have no objection.
Mr. Lustig?
Good morning, Your Honor. In respect to the rabbi, I didn't quite hear where he was going to be. Was he going to be somewhere where he was going to be sworn in? Because if he's not, I'd object to it.
If he's going to testify, he's going to be sworn in. So where is he? Is he available now? Do you want to do him first?
Can we make arrangements for him to?
We need to make the arrangements, and I don't know that he is somewhere that he can be sworn in or before a notary. Does he need to, that needs to occur?
He needs to be sworn in by my clerk. He can do that over the phone, right?
Okay.
But he needs to be,
Well, we can get the number. Well, I'll keep it brief, I assure you, and thank you.
well, actually, let me, is that appropriate as long as he's on the phone?
No,
sworn in
Your
by my
Honor,
clerk? No?
it's my understanding that there would have to be a notary or someone that would swear him in his presence, not by phone. If the court so chooses, that's fine with me. But I didn't realize it was going to be an evidentiary hearing to that extent. But to the extent the court's granting that, that's fine. I just would think in most instances that the notary, someone would be present.
Well, it's the kind of thing that if the court has advance notice of, we can take care of it, and I had no advance notice of this. I have taken testimony in the past where I need some assurances that he is who he says he is, but where is he going to be?
He's in North Carolina, and we can give you the phone number. He's on vacation, I think. Is he on vacation, I believe?
Why don't you make arrangements for him to call in? If you need to, talk to Debbie about how to make those arrangements, and we'll move on with whatever witnesses you have. But let's get underway.
Thank you.
And it is, I didn't specifically set it for an evidentiary hearing, but this is Ms. Riker's opportunity to carry her burden of persuasion. If she feels she can do that by argument, she can do that. If she feels she needs witnesses, she can do that. But as I said, I'm telling both parties, I'm not going to sit here as a probate judge or a guardianship judge. We're not reopening everything that happened in front of Judge Genden.
Yeah, thank you
Got it?
very much.
All right, call your first witness.
Deborah Rockland?
All right, come on up to the witness stand over here.
Go get that number.
Please raise your right hand. You solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth.
Yes.
State your name and spell your last name for the record.
My name is Deborah Rockland, Debra, Rochlin, Rochlin.
Rochlin?
Yeah.
All right, Ms. Rochlin, you're under oath. You may proceed. And try to keep your voice up and speak into the microphone. You're being recorded.
Right,
All right.
thank you, Your Honor.
Good morning, Ms. Rocklin. I briefly just would like to ask you about some interactions that you described in an affidavit recently with Judge Genden. Could you, you had a conversation with Judge Genden recently, is that correct?
Correct. I went to a hearing in April, And within 2 hours after the hearing, I received a phone call from Judge Genden.
What was the hearing pertaining to briefly?
I was called by Rabbi Farber. I had an interaction over the telephone with him in regards to my retention of services to represent Helen Stone.
And what was the substance of the phone call?
Basically to describe to me the issues that were going on in a guardianship in Dade County. And I was advised by Barbara Stone what was happening in that hearing on that particular morning, and I was requested to represent Helen at that hearing.
Oh, certainly. I'm sorry if I wasn't clear. Rabbi Farber, when he called, Judge Genden, when he called you to speak with you, can you tell the court what he said to you, what the conversation?
I've been practicing 29 years. I've been practicing since
Object hearsay.
1986.
I'm sorry, what's the objection?
Hearsay not subject to an exception.
Question was, what did Judge Genden say to you?
Admission by party opponent, the statement against interest.
It's not a statement against interest. I guess it's an, all right, overruled. It's an admission. Go ahead.
I was shocked to receive a phone call from him. I haven't never appeared in front of him. I never received a phone call from a judge after a hearing that, as far as I was concerned, the judge wasn't part of. And he told me that he heard I was in a hearing in Broward County in front of Judge Michael Kaplan, and he's planning on filing a bar complaint, but he's going to allow me to explain myself to him. So I explained why I felt I needed to be at that hearing, and I explained that I really didn't get a chance to say too much because Judge Mr. Lussick objected for my appearance at the last minute. I had not filed a notice of appearance. I was just retained that morning, and I didn't really say anything. And I said, I don't understand how you're calling me. I don't understand what any of this is about. And he started going off on some tangent against Barbara Stone and describing ankle bracelets and all the different scenarios that were happening down in Dade County. And I said, that's not why I went to the hearing this morning. I think it's horrible that the daughter and the mother aren't seeing each other, and if the woman's that sick, and the rabbi retained my services, and he just starts espousing the law and screaming at me. He started getting kind of belligerent to me. And I said, sorry, Your Honor, that's not the way my interpretation of what happened. And then he said, well, I heard you in front of Bernard Shapiro yesterday on another guardianship, and so you should know guardianship law. I says, well, then obviously Mr. Lussick went back and told you
Your Honor, I'm sorry.
about this
Judge.
hearing today.
Please stop.
Ms. Rockland's prior consistent statements are not admissible.
That's sustained. You can testify about what Judge Genden told you, but not what you said.
Not what I said?
Right.
Okay.
You were mentioning what, Mr.
Are you
Lussick?
referring to a document of some sort?
Oh, I have a copy. I looked down, but I'm not really.
All right. Let me just remind you, you're supposed to be testifying from memory. If at any time you need to have your memory refreshed, you may ask to do so.
Okay.
But you're not to be reading from a document or reciting from notes. You're being asked your recollection. Okay?
Okay.
ahead.
Absolutely, Your Honor.
May I ask you, Ms. Rockland, were you reviewing your affidavit?
No,
Okay.
my file's closed now. I was just looking down. I guess I'm nervous being on the other side of the podium.
All right, Ms. Rockland, if at any time you feel a need to refresh your memory, just say so and you can look,
Okay.
but you shouldn't be reading from anything.
Absolutely.
All right, go ahead.
Thank you. You were discussing what Mr. Lussick said to you at this hearing.
No, Judge Geden told me that Mr. Lussick was told that he should come back to him after a hearing and let him know what was going on.
Was there anything else that was said during the conversation?
He wasn't happy with my responses to him that I've filed in the affidavit that I filed. And he told me he was filing a bar complaint, and he has.
Had you already executed the affidavit when you received the phone call?
No, I wrote the affidavit after receiving the phone
right.
call. I was shooken up after the phone call, and I wrote it down because truthfully, I wasn't sure that it was really the judge that called me. I thought perhaps it was a hoax. And I actually called back the number that called me, and that number went to a bailiff who said that anybody could have been, that phone number comes from the courthouse, so it did not have to be, that particular phone that I was dialing. It could have been any of the phones in the courthouse.
What is the substance of his objection to your representation of Ms. Stone?
He was arguing, not arguing, well, he was discussing with me about what was going on in the case and telling me that he made his rulings and he's right and he doesn't know why I'm interfering with anything.
Okay, so, are you able to tell the court what the substance of the complaint that was filed against you, the grievance?
I don't know if I'm allowed to do that. I don't know if I'm allowed to do that under the bar rules. Other than to say I have a bar complaint here that was filed on May 7th.
All right, you can testify from memory about what it was, or Ms. Schwager, if you want to comply with the proper foundation to put it into evidence, you can do that.
Okay.
But you can testify if it's within your knowledge what the complaint said. Yeah, you can testify about that.
That was all I'm asking for. The basis for the bar complaint, was it something that you spoke about in conversation, or was what were the
He
alleged
reiterated basically the conversation that he had with me about the history of the case with Helen Stone, and that he had the jurisdiction, and he didn't know why I was up in Broward County. And then he admitted in the bar complaint that he told Roy Lussick to let him know exactly what happened at the hearing in front of Judge Kaplan, and to report back to him. And he didn't, he thought it was absurd that I was representing Helen Stone and that I was involved in this case. And then he, at the end, said something like, who could imagine what she would have said if she was allowed to speak before the court?
What is your area of practice?
My area of practice is civil litigation. So it's any type of civil litigation, from family law to guardianships to probate, landlord-tenant.
Did you withdraw because of the call or the bar grievance?
I was pretty shook up after receiving a phone call from a judge after 9 years of practicing, and not that I'm in my twilight years, but I don't need all this aggravation. I don't need to be in the middle of major chaos. And I called Barbara and I said, I don't want any part of this.
So, did you withdraw from the representation?
Well, I didn't ever file a notice of appearance, so I didn't file anything at that point after that.
Is it your, do you do guardianship law?
Yes, I do.
How long have you practiced that?
I've been practicing probably about 20 years.
Is it your understanding that Helen is entitled to an attorney under the probate code?
Yes, and she should have been
invading the province of the court on an issue of law.
Sustained. Also on leading grounds.
Do you have any reason to believe that your representation of Ms. Stone was unauthorized?
Since Helen couldn't speak to me herself, I felt that a third party that represented to me that he felt that Helen needed an attorney. I didn't have any issue with representing her at that hearing based on my conversation with Rabbi Faber.
And is Rabbi Faber Helen Stone's rabbi?
Correct.
No further questions. Thank you.
All right, Cross. First, Mr. Glantz.
No questions.
Mr. Lustig.
Yes, please.
Okay.
A few, I promise. Ms. Rochlin, good morning.
Morning.
Do you recall what the...
I'm sorry, you need
Mr.
to talk into a microphone.
Mr. Lustig.
I apologize.
Yeah. So, please.
You need to go get some.
I just prefer to stand over there.
Yeah, it's a little different over here. You can be seated, you can stand at the podium, but if you need to approach the witness for any reason, ask for permission, and I'll give you.
Not a problem, Your Honor, I
But,
apologize.
You can't stand next to it.
Ms. Rochlin, do you recall what the pleading was pending at the hearing before Judge Kaplan that morning?
It was an injunction.
An injunction?
It was for continuous abuse over and over and over again.
In fact, it was before the Domestic Violence Division of Broward County, was it not?
Okay, yes.
All right, and in fact, it was for repeated domestic violence that was filed by Barbara Stone on behalf of Helen Stone. Is that not correct?
Yes, it's
And it was
correct.
against the guardians of Helen Stone, correct?
It is what it is, yes.
Okay. In fact, the reason that Judge Kaplan didn't allow you to speak was not because you didn't file a notice of appearance, it's because you didn't have standing. Is that not correct?
Objection, speculation.
If it's within her knowledge, overruled. You can answer the question
I
if the
think
answer's
it's,
within your knowledge.
I'm thinking what happened at the hearing. I think there's probably a transcript to the hearing, but it's probably twofold. It's probably because, one, that courtroom, you have to file a notice of appearance before you can speak. I've been sent away before unless I ran across the street and got my notice of appearance. And then, two, you argued standing.
That's correct. And the judge ruled this because you didn't have standing, correct?
I asked and answered it, but I think it's twofold.
You believe that that's what the judge ruled. Is that correct? Is that what you're stating?
I would have to look at the transcript, but from my memory, it was for both reasons.
All right. And you've already stated before the court that you have guardianship experience, correct?
Yes.
All right. And to your knowledge, once an individual has been adjudicated incompetent and there are guardians that are appointed for that incompetent ward, can that ward hire an attorney by herself or himself?
Objection, calls for a legal conclusion. If you'd like to take judicial notice of a rule, I'll be happy to.
She's testified she has experience in guardianship, so if it's within your knowledge, you may answer. Overruled.
I would have to do further research, Your Honor. That's not my only area of expertise. I don't consider myself an expert guardian attorney. It's one of the areas of law that I practice over the 29 years of practicing.
All right. Okay. Two more questions, please. It'll be very short. You were aware of the fact that Helen Stone had appointed guardians, correct? At the time of the hearing?
You made that clear to me outside of the courtroom and told me that I should not be going into that courtroom.
Well, now that you mention that, I did state more than that, did I not to you? No? You don't recall anything else? All right. One further question. Isn't it a fact that you were first contacted by Barbara Stone before you even spoke to Rabbi Farber?
Is that relevant?
There's no objection. Answer the question unless I sustain an objection.
Barbara prepared me that I'd be hearing from the rabbi in regards to the issues at hand. Yes.
Did you meet with Barbara Stone before you spoke with Rabbi Farber?
Did I meet with her first? Yes, I did.
All right, thank you. No further questions.
Any brief redirect?
One redirect. I cannot hear you. Are you aware that Helen Stone has no lawyer?
Yes.
And who does Mr. Lustig represent, to your knowledge, in this case?
He represents Blair Lapidus, the guardian, and I think Jacqueline Hertz.
And you've read the pleadings in this case, is that correct?
Some of the pleadings, yes.
Are you, is it your understanding that the guardians have been accused of abuse and neglect and exploitation of Helen?
Right.
So,
That was the repeat violence that was being dealt with in front of Judge Kaplan on that morning.
are you familiar with the federal rules at all regarding the procedures that they use to appoint for an incompetent person?
No, I'm not.
Okay. That's all. Thank you.
All right, thank you, Ms. Rochlin. You may step down. Call your next
Thank you.
witness.
Barbara. Go.
Yes.
Barbara Stone?
No,
Oh, you can take the number to her.
you're represented by counsel. Let counsel do it.
I'll take it to her. Thanks. Just Barbara Stone.
All right, Ms. Stone, come on up to the witness stand. I see you're bringing up documents. The same admonition goes to you. You're to testify from your memory only. If at any time you feel the need to refresh your memory about something, you can ask permission to do so, but you're not to be reading from anything from the stand. You understand? All right. Debbie, go ahead.
Do you solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth?
Yes, I do.
Please state your name and spell your
Barbara
last name for
Stone.
the record.
Your Honor, I'm sorry. Can I just clarify what the scope of this examination will be?
I've made it clear what the scope is going to be, and if she exceeds it, you can object. Okay? I'm not sure you spoke into the microphone enough. Please state your name and spell your last name for the record, Ms. Stone.
It's Barbara Stone, S-T-O-N-E.
All right, you may proceed.
Ms. Stone, I wanted to go into pretty much straight into the reason that you're here today for an injunction. If you could characterize the proceedings as a whole, would you say that you have received due process?
There has been absolutely no due process whatsoever.
And can you point out the specific ways in which you feel you've been denied due process?
There's never been evidentiary hearings. There's been orders that have been pre-signed. I've been brought into court not to deal with the issues at hand, but I've been retaliated for speaking up. And I just want to say that I have two requirements to speak up. First, as the daughter of someone who's being abused, I'm required under the statute 825 to report abuse. And as an attorney, I'm required under the Florida bar rules to report wrongdoing by an attorney and by a judge. I have been given orders telling me that I cannot speak up, that I cannot report abuse under other mandates. So the orders that I've been given have required me to violate the law.
And what kind of repercussions have you, or retaliatory acts have you experienced as a result in these orders, in the orders that were issued in the guardianship?
When I spoke up to try to protect my mother as her advocate, as I'm required to do, and as an attorney, every time I spoke up, the retaliation became more and more intense to the point where I was arrested. I've been to jail 3 times for protecting my mother. If I had not have protected my mother, she would not be alive today. There's no question in my mind.
And speaking of the orders that were issued in this case, did you feel, you mentioned that you did not have any evidentiary hearings on the orders that were issued in the case. That's what accurate to say?
There has never been
Hold
an
on, it's an
evidentiary
objection.
hearing.
Here's the objection.
Apologize.
There's an objection. Let's hear the objection.
Irrelevant. I believe the court is stated it's not reopening the guardianship. What I hear are questions that are trying to do just that, to ask this court to inquire into the orders that were issued, or to somehow ask this court to pass judgment on those orders. So it's irrelevant.
All right, I think so far the answers have been relevant, but what's the pending question?
May I respond to that?
Not until I rule on the objection. Well, we have a court reporter. Can the court reporter read back the last question?
You mentioned that you did not have evidentiary hearing on the orders that were issued in this case. Is that accurate to say?
Overruled. Go ahead, you may answer.
The answer is there has never been any evidentiary hearing. So there's one order after another order after another order, and they all got more and more retaliated, and they started with no evidentiary hearing whatsoever. And the background of this case is a woman who's gravely ill, who has no due process, and her daughter is being denied due process and being told to violate the law and not speak up. And the retaliation has become so incredibly intense that I fear every day that I'm going to be arrested again. I've been in jail 3 times for protecting my mother and exercising my right of free speech.
let me just talk about the first time that you were arrested. I'm sorry, let me back up. Would you characterize, how would you characterize the court's treatment of you in the beginning of this guardianship?
I had been told, I had objected at the very beginning to the way my mother was being treated. She was denied visitation by one person after the next person after the next person. And so the few times I was denied the ability to see my own mother when I objected to medication that she was given. So the whole thing was never about a guardianship. It was about protecting people who I had reported a pattern and a practice of wrongdoing. And so the guardianship became all about me and my right to free speech and my right to protect my mother. There's documented evidence. There's medical evidence. There's medical evidence that my mother's stomach was cut open.
Hearsay.
Hold on.
Objection, hearsay.
She's referring to medical evidence.
And
The objection to not being responsive to the question will be sustained. Ms. Stone, you're being asked specific questions. Answer the questions.
Yes, sir.
I believe one of the first things what was the first arrest for?
The first arrest was when my mother was in a facility that they called a rehab facility where she wasn't getting appropriate rehab, and her food, she was being denied food because she had a feeding tube implanted in her stomach, and I learned that there was no medical evidence for her need to have a feeding tube implanted in her stomach. So my mother wasn't being fed, and my mother wasn't being given any water or anything to drink. And so she was very unhappy, and she said to me, "I don't know why I'm here." And so I left and I took her for lunch, and I basically got arrested for taking my mother to lunch.
Were your mother was at the care facility at the time. What was the name of it?
It was called Palm Gardens, I believe.
And is that where you took your mom from when you
Yes.
left? Did your mom go willingly?
Of course she did.
Did she ask you to go, or did...
She was very unhappy. She wasn't happy with being in the facility. She didn't understand why she'd been in the hospital. She didn't understand why she wasn't in her home.
And you meant, what happened that caused you to become fearful for her life at that point in time?
Okay, well, it had happened over a period of time. It wasn't something that just happened over a course of a day or two. If I may, the court probably understands
Briefly.
that the guardianship was established because I established the guardianship to protect my mother from abuse.
Your Honor, objection. We're now crossing,
What's the objection?
we're now crossing that line into the guardianship issues in respect to the guardianship law and the guardianship itself. In addition, and I apologize, I should have started with what I'm about to say. I had no idea that we were going to have witnesses in the courtroom. I'd asked that the court invoke the rule in respect to the witnesses now. I realized that now that there must be a litany of witnesses here.
All right, the objection to beyond the scope of what is relevant at this hearing, so it's beyond the scope and relevancy objection will be sustained. The rule having been belatedly invoked, I will allow that. Anyone who is in the court right now who is a potential witness should leave. And I'll put the burden on Ms. Schwager to identify anyone who is in court and ask them to leave.
Witnesses?
Anybody who you anticipate, the rule's been invoked, so anybody who you anticipate calling as a witness should leave the courtroom.
Ms. Rochlin, I presume, can remain? I don't anticipate calling her again.
As long as she's not going to be recalled, she may stay.
Thank you, Your Honor.
All right, thank you. But the objection was sustained. We're getting far afield. Let's bring it back in.
I primarily just would like to speak to you about the specific orders that you complain violated your rights, your civil rights. And do you contend that your civil rights were violated each time that you were arrested?
Absolutely, absolutely. My right of free speech was removed from me in the orders. My right to protect my mother, to protect my family, was removed in the orders. My right to report abuse was removed in the orders. Everything is a secret. Everything is very hush-hush. Everything is very under wraps. Nobody knows what's going on with regard to my mother.
Were you arrested for merely contacting your mother?
Actually, I wasn't arrested for contacting. There was an order to show cause that was issued against me because I contacted the facility where my mother was at one time to find out where my mother was. I was arrested. I'm sorry. Could you repeat that question?
I just asked if you were arrested for contacting your mother, and you explained that it was for contacting the facility.
That was at one time an order to show cause. With regard to being arrested for contacting my mother, there was again, all of these orders were issued on the basis of prior orders that were barring me from contacting or reporting abuse of an attorney or a judge or my mother. And so at one point, I had gone to the police station and I had...
Well, let's break for a moment, if you will, so that you can stay with me. Judge Genden had a hearing where he discussed the injunction. There was an injunction at one point against you. And do you recall whether he stated what the grounds were for the injunction, or any statements that he made about that injunction?
Objection, Your Honor. When, where, which hearing? There have been a number of hearings. We don't have any dates. We don't know what.
All right, Ms. Schwager, I'll allow you to lead in this instance because you're trying to pinpoint a specific thing. It'll save us some time. But Mr. Lustig's objection is well taken. If you're going to lead her to the right thing and let us know where she's being led.
May I add one additional ground of objection, that the best evidence of what transpired at the hearing is the record, not somebody's recollection.
That's true. Let's see how far this goes, and I'll take it with a grain of salt if we're just going on recollection. But first, let's establish what hearing and what you're asking her about. And let me ask you, Ms. Schwager, are you intending to offer anything into evidence, or is it already in the record?
I would like to enter the court orders into the record and ask the court to take notice of the orders and that they are what I'm reflecting them to be.
The first question is, are they already in the record as exhibits to any of the pleadings?
Oh, I don't believe so. I don't believe all the orders are.
The second question is, what are you talking about? What orders, when, where, and what court?
Certainly. There's an order for a temporary injunction, and it states that it's for violence, but that's what I was getting into. And a long discussion by the judge about the fact that it wasn't.
The defense lawyers are entitled to know when and where, and so on.
Okay, I handed them the exhibit if they'd like to look at it, and there is, this is contempt, excuse me just a moment. I'm specifically speaking of, first, the motion for order to show cause. It's about the temporary injunction against violence from Barbara Stone. It's an order that was filed by the guardians. Mr. Lustig filed it.
First of all, Ms. Stone's been in a lot of courts. First of all, let's start with what court are we talking about?
I'm just speaking of the guardianship proceeding. I'm not here to talk about other lawsuits that were filed.
So you're specifically asking about now is a TRO that was entered in the guardianship proceeding?
An injunction?
An injunction.
Yes.
All right. Defense counsel, are you familiar with what she's talking about?
If I could just have the date, Your Honor. There have been a number of motions and pleadings that have been filed.
As I said, please tell us the court,
Thank you.
the date.
The date. Date of the motion filed by Mr. Lustig was the 11th day of February 2014. And there's an emergency order that goes along with it because it's for contempt. It says 12, wait, sorry. I'm sorry, this is a different one. That's the document that I'm speaking of. The first one, that February 11th.
February 11th, 2014, TRO or injunction entered by Judge Genden in his court. Is that right?
Yes.
No, Your Honor.
No.
It's a motion. I'm
It's
sorry.
a motion. It's
I'm
not an
sorry.
order.
No, I apologize. It's an emergency order for contempt and temporary injunction. It's what it's called, against violence from Barbara Stone, but it's actually an emergency motion filed by Mr. Lustig.
It's not
Could
an
we
order.
have the date, please, Your Honor?
The date is February 11th, 2014.
So you're asking her about an emergency motion filed by Mr. Lustig on February 11th, 2014. To the extent you want me to consider what's in the motion, then
That's not what it's-
you need to properly move it into evidence, or if it's coming in without objection, I'll look at it if you can establish relevance. Ms. Stone may testify to the extent you're asking her what she did in response to a motion or something along that line, and that's relevant to what I'm here to decide today, you may ask, but I'm not going to have Ms. Stone testify to the facts of a motion filed by Mr. Lustig. So
Certainly,
where are you going with this?
Okay, I apologize. I just would like to ask in general what this motion and order was for and what statements the judge made, because he contradicted the substance of this motion. He later clarified the motion, and Mr. Lustig is attempting to characterize my client as having committed violence against her mother. And the whole basis of the injunction was domestic violence when there was no violence, and the judge admitted it.
He's not alleging that in the action that's pending in federal court before me. If there's something that Judge Genden did that is in response to the motion you're referring, and if you believe that's relevant to Ms. Stone's claims in this case, it's pending before me, I'll allow only that limited inquiry, but I am not going to allow Ms. Stone to testify about the substance of a motion that was filed by Mr. Lustig in court a year and a half ago. So focus on what you're trying to get accomplished in this case, in this court, and if there's a relevant question to ask Ms. Stone, you may do so. If you have to ask a preparatory question to guide her in the right area, you may do that, but she's not going to be testifying about something that Mr. Lustig filed in court. Does that satisfy to some degree satisfy the defense objection?
Yes, Your Honor, only again, just for clarification, I have no idea which order. She stated that it was February 11th motion that was filed in 2014, but it's not titled the way counsel says it's titled. So I just want to make sure we're talking about the same document.
Mr. Schwager, you know the rules of court. If you're talking about a document, show it to defense counsel, and then you may proceed.
It's in the, in fact, it's the first one on the top, right here.
Is this, I apologize, Your Honor. Is this the document?
Yes.
Okay. Your Honor, for clarification purposes, counsel has taken pages from other pleadings and placed it into the pleading that she's proposed to question Ms. Stone about and has spoken to the court about. The document that I believe counsel is intending to use is an emergency order for contempt and temporary injunction against violence from Barbara Stone. Is that correct?
That's correct, but in the
Okay,
first line
that-
it says on the emergency motion.
Excuse me, if I may. That particular is not a motion. That's an order by the court. And it's an order by the court dated December 20th, 2013, not February 14th.
It says certificate of service,
Ms.
February.
Schwager, why don't you proffer to me what it is you intend to ask Ms.
Apologize.
Stone, but we're not going to revisit all of the issues and all the things that were filed in the case in the state
No.
court.
I just
What's your
want,
point?
my point is I would like to speak to her about the orders to show cause and that resulted in her arrest.
If you are asking her questions about orders that came from Judge Genden or any of the other defendants, or anything that came from the other defendants, that she believes is a violation of due process or is retaliation, you may ask that. But we're not going to go through everything that was filed, especially if we're not going to identify them properly. We're not going to go through all the documents in the state case. So if you're asking specifically about the issues that are before me, ask the question.
Thank you.
But if you look like you're about to refer to a document, are we clear on what the document is yet, or no?
It is an order for contempt and temporary injunction against violence from Barbara Stone. I'm incorrect, and I had, unfortunately, 2 documents stuck together, and the second one had the date of February 11th, 2014. This one does say 12/20/2013. I apologize, a little nervous and my hands are...
All right, so you're not talking about the motion filed by Mr. Lustig on 11/14. You're asking specifically about an order from Judge Genden on December 20th, 2013. All right, you've identified the document. To the extent that you're going to ask a question that is relevant to the proceeding that's before me, you may proceed.
Do you recall receiving a copy of this order? Let me show it to you. May I pray it, Your Honor?
You may. Should have that marked though.
Oh, I'm not going to Exhibit 1. And
It's marked as defendant exhibit 1. Ma'am?
Yes.
All right.
I'm not 100% that I recall this, but as I do recall, or to the best of my recollection, this order was given to me while I was in jail, so there was no due process. I wasn't at a hearing, and of course, I never attended, and there was no evidentiary hearing.
So that particular order was that something that resulted in arrest or additional incarceration for that order of contempt?
This was just another order in a line of retaliatory orders, and it's just another example of orders that were issued without any evidentiary hearing. May I just say that to issue an order accusing someone of violence without any evidence or without the person present is certainly a violation of my due process.
Objection is sustained.
Didn't the judge acknowledge on multiple occasions that he understood there wasn't any violence in the case?
Yes, he did later.
And so, what is your understanding of what the injunction was for?
I never quite knew what it was for.
Do you recall what the judge stated about this injunction?
I'm sorry, which?
The basis for this injunction. Well, it says violence, against violence. Do you recall what the judge said about it? You said that
there was never any discussion about it. There was never any hearing. There was never any discussion.
Well, I think it was in later hearings, and I have the transcript if that would be easier.
Oh, okay. Yes, I do. I believe that at a later hearing, an order to show cause hearing, I was accused of making a phone call to the facility where my mother had been, not where she even was, to find out where my mother was. And then an order to show cause issued threatening me.
Is there an objection? What's the objection?
First of all, Judge, we're going beyond the scope again. Second of all, from what I'm listening to, the witness is going beyond the questions that are asked.
Yeah.
And then not responding to the questions that are asked. We're on to another order other than the order that's before.
Objection is sustained. It's beyond the scope of what we're here for today. It's also non-responsive to the question. Ms. Schwager, please, let's conduct this examination as questions and answers and not an opportunity for Ms. Stone to go on at will about conclusions about ultimate issues, etc.
Thank you. Did you have an attorney at the time this order was issued?
I don't believe so.
So were you given prior notice the order to show cause before you were the contempt note? Were you given notice an order to show cause do you recall, prior to receiving that contempt order?
No,
And it's your recollection that there was no hearing?
I wasn't present at the hearing.
Has Ms. Lapidus or Hertz or any party ever brought forth any evidence of violence or allegations of violence that you're aware of?
No,
Has anyone explained to you why that's an injunction against violence?
no.
Ms. Lapidus and Ms. Hertz claim that they asked, is it your understanding they asked for protection for imminent harm from you?
I believe that's what this document says, but I didn't know anything about it.
Did either, I realize you may have had disagreements, but have you ever threatened or exhibited violence towards either the guardians, co-guardians?
No,
Have you ever been accused of violence against anyone in your life?
no,
So, do you believe that was something manufactured to keep you away?
absolutely.
Do you recall how long that the injunction? Well, how many injunctions have there been? Do you recall?
I don't recall.
Several.
Several.
Is it your understanding that an injunction in probate court would need to be based upon violence?
Of course.
Opinion on an ultimate issue of law.
It's asking for
Withdrawn.
All right.
Tell me about, again, the first arrest you mentioned was when you took mom out of the facility.
Objections repetitive, Your Honor.
I'm asking the question. May I ask it?
You're asking the question, but I'm going to bring you back again. We're here for a specific issue about Judge Jensen's ability to enter orders, the validity of his orders,
Right.
etc. Focus on that.
Okay.
So to the extent
I
that the
just
question
wanted
is,
to-
the objection's relevance, the ruling is sustained.
After the first arrest, you recall what you were arrested for the second time?
It was my understanding that an injunction, an ex parte temporary injunction expired after 14 days.
Okay, so did you, where did you gain that understanding?
There's a
Objection.
statute.
Objection.
Overruled.
Your Honor, calls.
Go ahead and answer.
I believe there's a statute, 683.
Did you go to the police about the injunction?
Yes, I did. I went to the police and I asked them if there was any kind of order that had been entered against me. And they replied that if there had been any order, and I do have a copy of the
Objection,
police
prior
report.
consistent statement and hearsay.
Sustained.
So your understanding about the second time you were arrested, your understanding was that was it a no contact order? Or what was it?
Objection misconstrues the testimony. That hasn't been stated.
What was the
Objection to
second?
leading is granted. Sustained, right?
The second time that you were arrested, I realize that some of these may have been injunctions, some were entitled no contact orders. What was the effect of it?
The effect was that my mother was isolated and I couldn't see my mother. And I couldn't report her abuse or have anyone else report her abuse.
And why did they, to your understanding, issue no contact order?
Retaliation.
Did anyone explain to you why you were being prevented from seeing your mother at all?
Never.
Did anyone ever tell you why you couldn't call your mom?
No.
or have you ever had an understanding of why your visitation was revoked?
My understanding is that I objected to treatment, that she was given medication that had been pulled off the shelf by the FDA, and I objected to that.
Okay. Were you, did you understand that you were bound from not even being able to know anything about your mom's well-being?
Objection, leading
Sustained.
question.
Was there an order saying, or do you recall, strike that. What was this third arrest for?
I believe I was arrested by the criminal judge when when she told me that I arrived in her courtroom late because I had filed a objection to the way matters were handled in the criminal court. I had never been told to be at her court at the time that she indicated I was supposed to be there later.
Is it your understanding that that a writ of attachment has been issued currently?
Objection, leading.
Sustained.
What orders are you aware of that are currently that are currently applicable that you have to follow from Judge Genden?
I'm not certain.
Have you petitioned for, one second, have you asked for a jury trial?
Yes, I asked for a jury trial. I petitioned for a jury trial.
Did you get it?
No.
In what case? In this case?
This
Or-
case, the guardianship with respect to your mother or you?
Are you not talking about the federal criminal case?
No.
You're talking about the guardianship?
Yes.
All right. It's been answered. You may answer if you didn't know. I thought you already did.
I'm sorry, the answer, no, I did not, I was denied a jury trial.
Is it your understanding currently that there's a warrant or anything of that nature against you?
There's been a writ of attachment that's been issued.
Do you know why that was issued?
I believe that was following my motion for the disqualification of Michael Genden, and then thereafter he refused or he denied the motion, and at the same time he issued a writ of attachment without an evidentiary hearing.
With respect to the writ of attachment, did you, were you served with an order to show cause prior to that hearing?
Yes, I was.
And did you attend the hearing?
I attended by phone, yes, I did.
Do you recall what the complaint of conduct was, the reason that you were having a contempt hearing?
There were several things that I believe were complained of, one of which was a statement by Blair Lapidus that somebody who she alleged was an attorney of mine appeared to see my mother. And so she alleged that I violated an order because an attorney that she alleged was my attorney went to see my mother.
And did she mention to you that she had any personal knowledge of whether this attorney visited your mother? How did that come about?
No, I think that she had made a statement in an affidavit that wasn't signed under penalties of perjury.
Objection.
That someone had
What's the
said.
objection?
Okay.
Your Honor, counsel speaking in reference to a document that has been filed. Responses are coming in response to a document that is of record. I'd ask that we see the document. I mean, they're speaking of a document, and I don't know what it is.
Is the affidavit in the record that's before this court?
No, and Your Honor, I'm not specifically asking about the affidavit. It was something the witness mentioned. So I'm not going to go into that.
All right, then let's not go into it.
the writ of error, I mean, the writ of attachment, was there any other that you recall, I mean, basis of why you're being threatened now with arrest?
I don't recall. I don't recall.
What orders are you challenging from the spring? Do you recall, like, were there any orders prohibiting you from, aside from the no contact, prohibiting you from other things that you're aware of?
The orders, all of the orders are prohibiting me from doing the reporting as a mandated reporter.
Okay, and I can go through these orders with you. The January order that prohibited you from filing anything in Judge Denden's court. You recall that order?
Yes.
You have the order? That order is in the record, Your Honor.
All right.
Apologize. I don't have it before me. I just want to ask you a few brief questions. I don't want to extend a lot of time. There was an order issued in January of this year, and do you recall the substance of the order, what you prohibited from doing or filing?
As I recall, the order prohibited me from filing pleadings in the court.
In Judge Denden's court or in the
Yes,
court?
in Judge Denden's court.
What pleadings did you file after that allegedly violated this order?
May I speak to the pleading that was filed just prior to that order?
The
You may
pleading?
answer the question that was asked. What pleadings, if any, did you file after you were told by Judge Genden not to file any pleadings?
I filed a pleading in Judge Jennifer Bailey's court, who was the administrative judge, requesting a transfer from Michael Genden to another judge. She informed me that I should file a pleading in front of Maria Korvic, who was the administrative judge in the probate court, and I filed a pleading in front of Maria Korvic requesting a transfer.
Did you file any pleadings that you recall in his court, in Judge Denden's court after the January
No,
order?
no.
And did you have a hearing of any sort finding you in contempt for filing that order? Filing the pleading?
Yes, I believe there was another order to show cause. Yes, there was another order to show cause.
That order to show cause was the hearing on May 4th.
Actually, there was a rule to show cause that I believe dealt with the violation of that order, and then there was an order to show cause that
Objection.
dealt with Blair Lapidus' statements.
What's the objection?
I would just like to talk to you.
Hold on, there's an objection.
I'm sorry.
Discussing the content of documents not in evidence, and it's vague as to time and place and so on. I'm having trouble following any chronology here.
I think the specific answer to the question was that after being told not to file anything in Judge Genden's court, she didn't file anything. And you were asking whether there was an order to show cause or a rule to show cause?
Yes.
And she testified that there were such orders. But she's not testifying about the content of them? All right, then proceed. What was your specific question, the last one?
Just about the procedure. Did you receive any? I was just asking you. I was attempting to steer this so we could speak about the May 4th hearing.
I think that's all already in testimony, that she received an order to show cause.
Right.
She appeared by phone. That
Yes.
gets
You
us
appeared
here.
by phone.
And then there's a writ of attachment.
Yes. But I just want to ask a couple questions about it, if I might.
Make it brief.
Did you have witnesses scheduled for that hearing on May 4th?
Yes, I did.
Who did you have present?
Elliot Bernstein was present.
And did you have a court reporter?
Yes, I did.
Have you reviewed the transcript from that hearing?
To some extent.
And do you feel that you were denied any of your rights, and deprived of your rights in that hearing?
There was no hearing. There was no hearing.
Can you just briefly tell the court what happened?
The motion to disqualify had been submitted. There was no ruling on the motion to disqualify. There was then a hearing set for the order to show cause. And then I requested that the motion for the disqualification be ruled upon. That was denied. And then there was no further hearing other than, as I recall, Michael Genden said, "I'm issuing a writ of bodily arrest," but there was no hearing.
Did you attempt to comply to the best of your ability with that order to show cause with respect to the May 4th hearing?
Yes.
And in what way, if any, do you feel that well, let me just ask you this. Could you please describe in the ways in which you sought to comply with the order?
Well, I made sure I had a court reporter. I made sure that I had witnesses available, and I made sure that I appeared.
And you mentioned you appeared by phone. So, what happened at the hearing?
Again,
Objection, Your Honor. I
Sorry.
believe this has been testified to already.
Sustained.
So you stated basically that there was no hearing. Did the hearing end abruptly, or what happened?
There was
Objection.
shouting.
Sustained.
I would just like to get to the bottom of what happened at the May 4th hearing and wrap that up, if you will.
Testified she had witnesses there, that she did not appear in person, that she attempted to appear by phone. She requested a ruling on the motion to disqualify. That was ruled on, and there was no hearing. Is there anything else that has to be covered?
Yes. The morning that you were supposed to be at the hearing, is there any reason why you were not there physically?
I was scared to death. I was scared to death because of the motion to disqualify had valid, legally sufficient arguments where there was a statement that my attorney and my mother's attorney had been threatened, and I was frightened. This was the third time that I had been threatened with arrest for speaking up.
Do you recall receiving any probate document or probate orders or notices that mention the word arraignment in probate court?
Yes, I do recall that.
Did you ever have an arraignment in probate court?
I'm not certain that I did. I'm not certain that I did. I don't understand the concept of an arraignment in a probate court.
Okay. And I can introduce that into evidence. You brought claims against Judge Genden for violating your rights with respect to the guardianship and specifically with regard to the arrest. Are there any other ways that you feel that you were deprived of due process or had your rights violated?
I never could quite understand. I felt like when I was bringing wrongdoing to the attention of the judge, that
Objection,
it would
not
be looked into.
Not responsive. I think the court can, on the face of the complaint that's pending, the court could certainly take notice of the legal claims. If that was the question, then it's irrelevant.
No.
I think it is responsive to the question, but the question asks for things that are outside the scope of this case to sustain. If it hasn't been alleged in the complaint, she doesn't get to allege it here, as far as due process violation.
What in your opinion, what makes you think that the orders that were issued against you are retaliation?
because they just kept escalating. Each time I would speak up. Each time I would try to bring matters to the attention of the court that I felt that should be brought to the attention of the court, I would be retaliated even worse. So nothing that I ever brought to the attention of the court, never once was anything, any petition, any request, never once was I granted anything, and towards the end, things were taken away from me that I didn't even, that were never even brought to the attention of the court.
Myself. Specifically, with respect to the arrest, what have you incurred?
Objection, Your Honor.
I'm sorry.
We've established that based on testimony of the witness that she says she's been arrested 3 times. Which arrest are you speaking of in respect to what?
Let me hear the whole question, and it's a good point. Be specific about which arrest.
What have your damages or your suffering that you've alleged from the arrest?
Which arrest?
All of them.
Question is, what damages or suffering have you incurred based on the multiple arrests? Any objections to that? All right, you may proceed.
Thank you. I worked for the most premier company in New York City as a real estate agent. I've now lost my job because my time is spent here trying to deal with the issues.
Objection not responsive. With respect to Judge Genden, only prospective relief has been pleaded.
We're not.
It's responsive, but it's not relevant. It's sustained.
You have been accused of and asked. It's been requested by both defendants that you be declared a vexatious litigant and denied access to the court. Can you explain the multiple filings that occurred, at least in the last year, and why?
Mm-hmm. You know, I think it's important that, may I ask, that when you're dealing with someone whose life is in danger, it's very scary. And so I had gotten testimony, I had gotten evidence, I tried to do what
Objection.
I can.
What's the objection?
It's non-responsive.
Again, I think it is responsive, but
I could be more indirect.
But it's an invitation for a 20-minute soliloquy is what it is.
Okay.
Please ask specific questions and we'll get specific answers. Don't ask her, why have you done everything you've done? All right?
Are you a litigator?
No,
Have you
never been in court.
any experience in
No.
litigation? No.
No.
And did you look for a civil rights lawyer, a guardianship lawyer to represent you in the cases where you filed per se? I mean, did you look for a lawyer and not find one, or did you just decide to represent yourself?
I looked for a lawyer and I was represented during various times, and then at the last minute, many times before a hearing, my lawyer would withdraw, and I never understood why.
Are you seeking some sort of vengeance against this judge or Mr. Lustig or the guardians in this case?
Absolutely not.
What is the reason that you're asking the court for the injunction?
I'm asking the court for the injunction because not only have my rights been protected and I've been denied due process, but I live in fear for being...
Objection, Rule 403, cumulative.
Overruled.
Continue.
I live in fear for being accused of I'm not certain. I mean, I brought my mother into a probate court to protect her, and when I raise objection and when there's things that I point out to the court, I'm threatened with arrest. It's a very frightening thing.
Have you been convicted of any crime as a result of these arrests that you've been arrested
No.
for? That's all.
All right, Cross? Unless anyone needs a break, how's the court reporter doing?
Going to.
Can't see you over there. Okay, defense counsel, you ready to proceed?
Yes, Your Honor.
All right, go ahead, Mr. Glantz.
Ms. Stone, are you a member of the Florida Bar?
I'm a retired attorney.
Are you a member of the Florida Bar?
Yes,
Today?
as far as I know. I was retaliated by the Florida Bar.
Are you today a member of the Florida Bar?
I'm a retired attorney and a member of the Florida Bar.
You are a member of the Florida?
Yes.
Nothing further.
All right, Mr. Lustig.
Promise to be brief. Ms. Stone, you stated to the court that you just don't understand why your attorneys withdrew from your case. Is that correct? In
Yes, it
guardianship?
is.
In fact, you had about 9 attorneys in guardianship. Isn't that not correct?
Yes, that is.
And isn't it a fact that you fired each one of them?
That's incorrect.
That's incorrect. Isn't it a fact that you filed bar complaints against some of your attorneys?
No, I did not file a bar complaint against an attorney.
Any
May I
attorney.
May I answer the question?
Yes, I'm
May I
sorry.
Allow her to
the
answer, please.
question?
You may proceed.
Yes, my attorneys withdrew, and I later learned that they had been given instruction or that they had heard from someone in the court with threats.
And who threatened them?
I don't know.
I don't know. Okay.
I would imagine that it was people relating to the guardianship,
Okay.
just
Did
as
you-
what happened to Miss Rochlin.
Did you file suit against any of your attorneys?
Not that I recall.
Not that you recall? You want to give any thought to that? You didn't file any suits against any of your attorneys? We'll go on.
Oh, yes, I did. Yes, I did. No,
All right.
no, I don't recall.
Okay, we'll go on. Ms. Stone, do you recall that there was a hearing before Judge Genden in an open court hearing, which you had due process, you had an attorney, to where there was an issue that you had requested to court to allow you to have visitation to your mother that had been previously revoked by the court because of calls that your mother made insisting that you be removed from her apartment. Do you recall that hearing?
No, that wasn't what happened at all.
Okay. Do you recall the hearing?
Do I recall a hearing?
Yes.
I recall a hearing being held, but not on the matter that you're raising.
You're stating that that hearing did not take place based on your counsel's motion for reconsideration regarding a temporary restraining order prohibiting you from seeing your mother. You don't recall that hearing?
I recall a hearing taking place based upon an order that was issued isolating me from my mother because I objected to her being given Miralax.
Please just
It was
answer the
removed.
question.
Your Honor, I have a copy of the transcript if counsel would stipulate to enter it in the evidence.
The question is if whether she remembers the hearing. Do you remember the hearing?
There was a second hearing. Yes.
Okay. Do you recall having an attorney present at the hearing?
Yes, and I recall that the order was changed outside of the
Ms.
presence
Stone,
of the
please just
court.
respond to the question
But you
that's
need a
asked.
complete
Ms. Stone?
response. Was there a
Ms.
hearing?
Stone?
Yes, there
You're being
was.
asked yes or no questions. You may answer yes or no. If you feel a need to explain, ask permission to explain. But you
Yes.
answer the question first, understand?
Yes, sir.
All right, you may proceed.
Do you recall having counsel at the time?
Yes, I do.
Do you recall that it was an evidentiary hearing?
May I explain?
You may answer first, and then if you need an explanation, the question is, was
Yes,
it an evidentiary hearing?
Yes,
And do you recall that you were present?
yes, I was.
And do you recall you had witnesses?
I don't recall my witnesses speaking, no.
I didn't state that your witnesses
Yeah,
spoke.
objection.
I asked.
What's the objection?
Best evidence? I have the transcript of, I believe it's Jeffrey Weinkel attended and Mr. Lustig attended.
That's,
Objection is overruled. He's asking questions that should be within her memory. The specific question is, did you have witnesses present at the hearing? What's the answer for that?
There were witnesses, yeah. Yes, I believe there was a witness.
okay. Do you recall that at that time Judge Genden, upon ruling, entered an order allowing you to visit with your mother during restricted hours, I believe between 9 and 5 weekdays and certain other hours on the weekends. Do you recall that?
May I just clarify? Do I answer the question and then I'm able to explain?
I've advised you, as a witness, when you're being asked a yes or no question, you answer the question yes or no. If you feel the need to explain, answer yes or no, and then say, may I explain? And you may explain. So
Okay, yes, sir.
first answer the question if you can. If you don't remember, then that's your answer. But first answer the question. If you need to explain, ask for permission to do so.
Yes, sir.
I would
Is there
just
an
like to object, just based upon the mischaracterization. I don't believe that this hearing, what's reflected in it was to get permission to go see her mom. I think that was a previous issue. This hearing that he's speaking of, let me see what date this is.
Are we talking about the same hearing?
What
All right.
what
What's
date
the date
hearing
of
is
the
he
hearing, if
speaking
you
of?
recall, Mr. Lustig?
I'd have to get the order, Your Honor. This was a...
Or if you
I'd have
can
to get the order. There's 7 volumes, Your Honor, and I apologize, of pleadings in this particular guardianship. Ms. Stone has already identified the fact that she's aware of what hearing we're speaking of. She was represented by counsel by Mr. Lowy. Is that not correct?
Yes, that's correct. I have no problem
Okay,
answering the
so
All right,
what
if you don't-
counsel's speaking of, I'm
All
apologizing.
right. If you can't identify it by date, that's fine, as long as if you can identify it with sufficient specificity that the witness knows what hearing you're talking about, and if plaintiff's counsel is also aware of what hearing you're speaking of, then you may proceed. Ms. Schwager, are you?
I'm aware now, thank you.
All right, go ahead.
Okay. At that time, Your Honor, excuse me, strike that. Ms. Stone, do you recall that the court entered its order allowing you for visitation with your mother?
Yes, may I explain?
You may.
Thank you. Yes, there was a hearing held where it was held on the basis of the prior order, and that's one of the reasons why I said that each of the orders followed problematic orders that denied due process. So that hearing was held on the basis of a prior order that isolated my mother from me based upon my objection to her being given Miralax. Not only did that order isolate my mother from me, but that order was issued so that the people that were going to supervise the interaction between my mother and I were the 2 guardians, the very people against whom I was alleging abuse. And I just want to say one more thing, that I feel that not only was my due process violated and that I was retaliated, but I feel that important federal laws dealing with the protections that
Ms.
are
Stone,
granted.
I'm going to cut you off even though there's not an objection. I allowed you to explain your answer to this specific question. It's not an opportunity to argue your case.
Okay.
Answer
But
the question. If you
yes,
feel
yes,
a need to respond, to explain your answer, you may do so. But it's Mr. Lustig's cross-examination. He'll proceed as he sees fit.
But I'm sorry, sir, but I didn't finish just one more explanation, if I may. I will not talk about anything else other than just one more explanation to that.
All right. If it's within the terms of the ruling that I just made, you may proceed.
Thank you, sir. Thank you. So the question was the answer to this order. And so, yes, there was an order, but then after the order was entered in the presence of press, the order was changed.
And how was that order changed?
The order was changed by having some handwritten note in the order saying that my presence was going to be overseen by aides that were assigned to my mother by Jacqueline Hertz and Blair Lapidus, but there was no initial to the change. There was nothing designating that the judge had actually entered that or written that in an order after the hearing was over.
Ms. Stone, in fact, the judge entered the order and put on the record exactly what's in that written order. Is that not correct?
No, that's not correct at
So
all.
you are now alleging that some person other than the judge changed the order?
Objection, asked and answered.
Overruled.
Is that what you're alleging?
Yes, I'm alleging that there was a change made to the order, and I looked at the transcript very carefully, and nothing in the transcript had anything to do with an aide being able to supervise my visitation. So when the order came out, there was nothing in the order that made that statement, and thereafter, the hearing was over. There was a handwritten note in the order that said that the aides who were appointed by Jacqueline Hertz and Blair Lapidus would oversee my visit with my mother.
In fact, Ms. Stone, what you're stating is not in that order,
Oh, but it
right?
is.
In fact, Ms. Stone, your counsel and you were given copies of that order once the court executed it and entered the 3 words that were entered in that you're speaking of. Is that not a
No,
fact?
that's not a fact.
You did not receive a copy of the order
It
at the
was only
hearing?
much later. No, it was only much later.
Much later. And your attorney didn't receive, strike that. Ms. Stone, isn't it a fact that your attorney prepared the order?
No,
No. Who prepared the order, Your Honor?
I don't know who prepared
You
the
don't
order.
know? Okay.
But it wasn't the order that was entered by the court.
All right. Now, Ms. Stone, just briefly, you've told this court you have not been given due process. In fact, did you not file on 2 occasions petitions to remove the guardians of your mother?
There was never a complete...
Ms.
Yes, I
Stone-
did. And may I explain?
First, you answer the question, then
Yes.
if you feel a need to explain, you may ask permission to do so. It's a yes or no question. What's the answer?
The answer to the question is yes.
Okay.
And may I explain?
You may.
Thank you, sir. Yes. I feel very strongly that the petitions should not have even been necessary for me to submit. I feel that when my mother went into the hospital...
Objection, Your Honor.
Yeah, Ms. Stone, when I tell you may explain, there's some yes or no answers that do require an explanation, but this is not an invitation to you to take over Mr. Lussig's cross-examination.
I understand.
The question that he asked, I don't think required. I gave you the benefit of the doubt, gave you an opportunity to explain, but not every yes or no question requires an explanation. He's going to follow up, I assume, with his questions, and if he doesn't, then your attorney can follow up on redirect. But this is
Okay.
Mr. Lustig's cross. You may proceed.
Yes, sir. Thank you.
Ms. Stone, on both occasions upon filing of those petitions to remove the guardians, you did have counsel in each respect, correct?
No, I don't think I had counsel on one of those occasions.
Well, the record would reflect that you had counsel for both. Notwithstanding, and on both petitions, were there not evidentiary hearings that were proceeded on?
No.
No. You don't recall attending evidentiary hearings on both of them?
I
Is that what you're
recall a
stating
partial
under oath?
evidentiary hearing.
Excuse me?
I recall a partial evidentiary hearing.
Well-
And then I would like to explain.
Ms. Stone, I'm just trying to get through this examination just with questions that are just quite simple, okay? Do you recall being at the evidentiary hearings on both of your petitions to remove the guardians?
I recall a partial evidentiary hearing that I would like to
Okay.
explain.
And do you recall on both occasions your counsels withdrew those petitions?
No, that's not what happened.
Okay. What happened, Ms. Stone?
I withdrew the petitions because then I sought to disqualify Michael Genden.
Okay.
Because I
Are-
wasn't getting a fair evidentiary hearing.
Are you saying now, under oath, that at the time you filed those petitions to remove the guardians, that you filed petitions to remove Michael Genden at that time?
I filed a disqualification for Michael Genden.
At that time?
It was around that time.
Around that. At the time that you filed those petitions and during the time that you had the evidentiary hearings, are you stating of the record that you filed petitions to remove Judge Michael Genden?
No, I'm not saying that.
Okay. Mr. Stone, isn't it a fact that you filed 5 complaints with the Department of Children and Family Services?
Objection. That information is privileged, confidential. I don't know how he has it, but I've not been provided a copy of it.
Well,
Is it privileged?
it's not
What's the
privileged.
basis for the claim of privilege?
These reports can't even be usually obtained without a court order. Certainly can't be obtained by counsel, opposing counsel. I don't know how he got them.
Mr. Lustig, are you asking about things that are privileged?
No.
Explain
No,
to
they're
me.
not. To the extent that I've asked her if she's filed it, she's previously admitted that she has filed them.
All right, you're not to get into,
I'm not getting into the context
all right.
of the examinations, other than the fact that they had been investigated.
Objections overruled.
Ms. Stone, did you not file 5 complaints with the Department of Children and Family Services regarding treatment of your mother?
I don't recall filing 5. I did file several, and may I explain?
You may.
In response to one of the complaints that I filed, the investigator said, "Do you think that I would really speak up
Objection to
against...
hearsay, and
Do you think that I would
Sustained.
speak
I
up
think that is
against
a
the judge?"
protected
That's-
abuse investigation.
That is.
Sustained as to hearsay, and also if there's a claim of privilege, you're not to go on the question. You've answered the question, and if the explanation is going to get into hearsay and/or privilege matters, you may not do that explanation. Mr. Lester, go ahead.
Oh, thank you. Ms. Stone, isn't it a fact that you filed complaints with the Miami-Dade Police Department and asked them to immediately go over to the facility where your mother was residing, that your mother was in extreme harm?
Could you repeat the question?
So isn't it a fact that you filed complaints with the Miami-Dade Police Department requesting that they immediately go over to the facility to where your mother was residing based on the fact she was in extreme harm?
I have made complaints with the police department.
Isn't it a fact that you've called 911 and filed an emergency complaint to send rescue over to your mother's facility where your mother's residing because she was in extreme harm?
No, I don't recall that I did that.
Are you stating under oath
Yes,
now
I'm stating
that
under
you have
oath that I
never
don't
made
recall.
Don't, please allow him to finish. Don't talk over each other. We have both a recording and a court reporter, so allow him to finish the question. So counsel, don't interrupt the witness.
I
Witness, don't
apologize.
interrupt counsel. Please state your
Apologize.
question.
Ms. Stoning, are you stating of the record now that you have never made a 911 police call for an emergency regarding your mother for services, rescue, to be sent to the facility where your mother was residing to remove your mother?
I'm saying I've made 911 calls.
I'm sorry, I didn't hear you.
I said
You're
I've
saying
made
you-
911
Oh, you have
calls.
made. Okay, thank you. Excuse me. Now, Ms. Stone, you've stated that you've been arrested 3 times, correct?
That's correct.
And am I correct in stating that you stated you have really don't understand why you were arrested?
That's correct.
Okay. Now, in fact, there was a court order in place at the time when you removed your mother from the facility to where she was residing, correct?
That's correct.
And that court order prevented you from interfering with the services rendered by the facility and the physicians and those parties that were there and interrupting your mother. Is that not correct?
That was the order that I've already made a statement that there was a handwritten change to.
Okay. But that's the order, correct?
That was changed, that wasn't in open court.
Objection, Your
wasn't-
Honor. May you please identify the order and the date?
I think it's pretty clear to everyone which order this is. Is that the order that you're talking about, the one that you say was changed, handwritten change?
Yes.
All right, what's your question about that order?
Okay.
Simply, was that the order that, what's basically
That was
the
in
arrest?
place at the time when you removed your mother from the facility.
As far as I know.
Okay. And in fact, you did not notify anybody at the facility that you were removing your mother. Is that correct?
I don't think that I did.
Okay. And in fact, you wheeled your mother right out of that facility.
That's right. That's my mother, and I wheeled her out of the facility because she wanted to leave the facility.
Because she wanted to leave the facility. Okay. And did your mother call you and tell you that?
She wasn't allowed to use the phone.
She wasn't allowed to use the phone. Okay. That wasn't the question. I asked you, did she call you?
No. Then
How did you know
actually-
your mother wanted to leave the facility?
Because I visit her every day.
And that was because the court had granted you the authority to be able to do that, correct?
To visit my mother?
Was that not correct?
Yes.
Okay. All right. And you wheeled your mother right out of that facility and took her where?
I took her for I took her for lunch at Denny's.
You took her for lunch at Denny's. Ms. Stone, you are aware of the fact that your mother had been given 3, what we call, in layman terms, chewing tests in respect to her ability to swallow food. Is that not correct?
That's absolutely a misrepresentation.
Okay. All right. And in fact, at the time when you wheeled your mother out of that facility, your mother had what we call a peg tube in her. Is that not
My
correct?
mother's stomach had been cut open to put a peg tube, yes, without an evaluation.
Okay, without an evaluation. And in fact, you were aware of the fact that her attending physician was the one who signed off and suggested that it had to be done because of the chewing exam.
No,
Is
I
that
wasn't
not?
aware of anything because I was never given medical records. It was only later.
You were never told that. Is that
No.
what you're saying of record?
That's correct.
Okay. But you were aware that your mother had a peg tube her, and at the time you wheeled her out of the facility,
My
correct?
mother had an end-of-life peg tube in her stomach.
End-of-life peg tube. Is that what it's
May I
called?
make an
Yes.
objection?
You may?
I think much of this is irrelevant, and I have some concern about, there's some laws regulating discussion, disclosure of another person's medical condition without their consent, and there's going to come a point, if we're not already, where in the absence of some expressed consent by the patient or an authorized representative, that this testimony is medically sensitive and should not be heard.
Mr. Lustig?
To that extent, Your Honor, I represent the guardians, and I can represent to the court that the guardians have given me the authority under HIPAA. And counsel is correct in what he stated, but to the extent that these are medical records, they have been presented previously, but I would tell the court that I have spoken with the guardians and obtained their consent to this limited scope in respect to this issue to identify that she had a peg tube on her at the time only, not to any other medical issues.
I'll accept your representation to the extent that it applies to what's been testified to so far, but your
Correct.
cross-examination is about, it seems to me, whether she understands why she was arrested on those occasions. It seems to me we're getting into specifics of the care of her mother, which is what I told Ms. Schwager, and I'll tell you as well, we're not getting into that.
No, I'm
Necessarily,
away
we've bled into some of that, but you're not to continue to go into specific discussions of Ms. Stone's mother's medical condition.
No, I will stay away from that, Your Honor. Ms. Stone, isn't it a fact that on the second occasion, the reason that you were taken into custody was because you lied to the criminal court judge?
No.
No?
Objection, asked and answered. She's already testified about the second time she was arrested, and it's just confusing. He's trying to confuse the witness with, no, he didn't even state the dates, or
Well,
it's just random questions about,
It's not random. We're talking about 3 different dates. We moved on from number 1 to number 2. I guess it's been asked and answered because she said no and you said no. But,
Okay.
so proceed.
just by,
But
sorry.
are you unaware of what arrest we're talking about? If so, then counsel, please eliminate plaintiff's
Yes.
counsel.
Yes.
Ms. Stone, do you recall walking into Judge Brennan's chambers? Excuse me, strike that. Do you recall walking into Judge Brennan's courtroom when you were ordered to be there at a certain time at 9 a.m. and you walked in over an hour and 15, 20 minutes late? Do you recall that?
No, I don't recall that. I
Okay.
don't recall being ordered to be in her court at 9 o'clock. I believe that she later said that I was ordered to be there at 8:30. There was no evidence that I was ordered to be there at 9 o'clock or at 8:30.
You don't recall being present at the previous hearing where the court ordered you?
No, I don't
Okay.
recall. I was present at the previous hearing, but no, I don't recall the
Okay.
order.
All right. And do you recall at the time before being taken into custody, the court asked you where you were?
Yes, and I told her that I was in federal court.
Mhm. All right. And what was the third time that you were arrested?
I believe that was the third time.
What would be the second time then?
I don't know.
You don't know when the second time was you were arrested?
Objection, asked and answered. I believe she testified that it was for calling the care facility and asking where her mother was or how her mother was doing, something to that effect.
We're talking
Well-
about she testified she was arrested 3 times. We've got the
Right.
one where she took her to Denny's. We've got another where she was or was not late to court.
And
Whether
the
it's-
third, and I'd ask you this third one.
Well,
What was
if
the
it's
third
not
one?
sequential, is there
If
a
not
third arrest?
sequential, what was the second one, which would have been the third one we're discussing?
What was the I don't recall.
You don't recall why you were arrested?
No, I don't recall.
Okay. All right.
No, actually, I was never given any order. No, I don't recall why I was arrested.
Ms. Stone, you were questioned in reference to the order that was entered by Judge Genden prohibiting you from making any more filings in the probate court without counsel, a Florida counsel. Do you recall?
Yes.
Okay. Did you take that up on appeal?
Did I take it up on appeal? No, I believe I petitioned for his disqualification based on the fact that he had threatened counsel for my mother.
So the answer is no.
No.
Okay. Now, you said you took it up on appeal in reference to the threat. You filed a writ of prohibition?
Did I file a writ of prohibition?
Yes.
Yes, I did.
In fact, you filed more than one, is that not correct?
Yes.
Okay. And what has been the ruling on all the filings in the writ of prohibition?
Well, I'm not certain what the ruling is. I'm not certain whether the ruling was that there was not going to be a review of it. I'm not certain.
Well, didn't you get an order from the 3rd District Court of Appeal?
I'm not certain what the order was.
Objection,
Did
Your
you
Honor.
get an order?
What's the objection?
The Honor, she's stating she doesn't know, and the order stands, it speaks for itself, I would think.
Well, she's an attorney, and she knows what an order says. It generally says either affirmed or overruled, or affirmed or, reversed, or if it's a writ, granted or not granted. If she doesn't recall, she doesn't recall, but it seems to me that she is able to answer that question. So, do you know the answer to the question?
So the answer is that I'm not certain whether there was a ruling on that or they denied hearing the petition. That I'm not certain of.
All right.
Isn't it a fact that on each one of them you it was denied the petition for a writ of prohibition?
Right. I don't know whether denial was that they denied. Well, may I explain?
Answer the question.
Yeah, I don't recall whether there was a denial of the petition or denial of a review of the petition.
All right.
All right. I have no further questions, Judge.
All right.
Thank you.
Brief redirect, and make it brief, and make it within the scope of the cross. Otherwise, it's not appropriate redirect. All right.
Yes, thank you, Judge. Your mother's guardianship, Mr. Lustig spoke a lot about visitation restrictions. Did you ever have the ability just to visit your mother unrestricted since the guardianship began?
Not since the guardianship began, which I thought was incredibly strange because I filed for the guardianship to protect my mother.
When, so the first order that came out, your visitation was restricted in some way?
Yes.
Wow.
That was the first order. That was because I had objected to the use of unauthorized medication. But may I just explain?
Nope. You
But
may
I
have to
don't-
respond to
that's-
questions that are asked.
Yeah, that's all I need. Has the judge ever confronted, Judge Genden, ever confronted you during a hearing about lawsuits between the two of you?
Objection outside the scope.
Sustained.
Let's see. Do you have anywhere that you can go for relief if you can't file pleadings in Judge Genden's court to see your mother?
No.
Objection, Your Honor. It misconstrues the order. The order states that she cannot file pro se pleadings. She can file pleadings so long as it's filed by an attorney with the Florida that's practicing and licensed in the state of Florida.
And I will
Ms. Schwager,
rephrase it, I apologize.
All right, go ahead, rephrase the
Part of the
question.
retaliation, have you been able to find a Florida bar member that can represent you in a guardianship matter?
Objection outside the scope.
It's not.
Overruled.
As I said, I've learned that my attorneys have withdrawn from my representation in some cases just prior to a hearing that was set. And so I feel like they've been retaliated or they've been threatened. And I'm certainly being retaliated for not being able to appear in court when I've never filed a pleading in violation of his order not to file a pleading. It's customary, from what I understand, if that's the case, that you file a petition to file a petition.
Were you ever, when you filed any any petition that was adverse to Judge Genden, even in his own court, like a disqualification, were you ever referred to another judge to decide the issue?
No.
Was Mr. Lustig at all your hearings in the criminal matter?
Yes.
Why exactly did you, were you so alarmed about your mother's care when you took her out of the facility?
Over a period of about 5 months, I had seen her where she appeared drugged. I had seen her where there was no food in
Objection
the
outside the
refrigerator.
scope, and this invades the...
Sustained.
I'll just ask you just quickly, and this is the last question I think I have, is why was there, without going into the medical, could you just briefly describe whether there was any sense of urgency for you to take her out?
Well, she had been denied food and water.
And so the reason that you took her out was because you were
I
concerned.
was very concerned.
Were you concerned that it was a life or death matter, or something?
What's the objection?
Objection leading and...
Sustained.
On May 19th, I think it was on May 19th, there was do you recall a criminal hearing, a hearing set in your criminal case? A recent hearing?
Yes.
Or maybe it was May 19th. Do you have a lawyer in that case?
Yes.
And is he still representing you?
No, he told me that he's going to move to withdraw.
When did you learn that he was going to withdraw?
I just learned when he was requested to get a continuance, and he was afraid. He said to me, I'm concerned
Objection,
about getting a
hearsay.
continuance.
Sustained.
Your Honor, I
And what
also-
hearing are we talking about? Is this within the scope of Mr. Lustig's questions?
Yes.
Well,
I believe it's, I'm getting confused about the dates, but it's one of the hearings in the criminal court that he was talking about.
No, Your Honor, that is not within the scope of my examination.
I suppose I can move on, that's fine. I don't-
Yeah, the objection sustained on both grounds. Move on. Let's keep it
Were you
within the
ever
scope of the...
referred, I'm sorry, were you ever referred to the district attorney to try your contempt actions? Or the state's attorney?
Did I ever?
Were your cases, these contempt cases that a judge found against you, were they ever sent to a prosecutor?
No.
And you don't have any knowledge, personal knowledge as to what your attorneys might or might not have received in particular cases, do you?
No.
Has there ever been a time in the entire guardianship where you didn't have a stay-away order or restricted?
No.
That's all.
All right, Ms. Stone, you may step down. Thank you. Ms. Schwager, it's 12:10. You may step down, Ms. Stone. I assume Ms. Stone is your longest witness, and I allowed you plenty of leeway in that. Are the others brief?
Yes.
How brief?
I would say, they're on the way. I would say pretty brief. They're, relatively brief.
What my question is, and really it's for everybody, I want to get this wrapped up before taking a lunch break. If we have to take a lunch break, we will. What I would propose is take, say, a 10-15 minute break now, and then come back, but then wrap this up without taking a full lunch break. Does that work for everyone? Ms. Schwager?
Yes.
Mr. Lustig?
Yes, Your Honor.
Mr. Glantz?
Yes, Your Honor. Will the court give an instruction that the witnesses
Yes.
not discuss their testimony?
Yes, and court reporter, can you live with that, if you're over there? All right, then we're going to take a 15-minute break. We'll be back then at 12:25. Well, let's make it 12:30, and we'll wrap up. I'm instructing you, Ms. Stone, and you, is it Ms. Rochlin? You're not to discuss your testimony with each other or with any other witnesses, and the witnesses who are outside who are expected to testify, they're not to discuss the matter with anyone. Does that cover it, Mr. Glantz?
Yes, Your Honor.
All right.
May I clarify?
Yes?
When you're saying not to discuss the matter, are you prohibiting them from discussing the case at all, or just the testimony today?
You may speak to the witnesses to prepare them for the upcoming hearing, or the upcoming questioning. But Ms. Stone and Ms. Rochlin, you may not discuss the case with each other or with any of the witnesses outside.
Thank
Does that
you.
cover it?
Yes.
Yes, Your Honor.
Okay. All right. And Ms. Schwager, you're an officer of the court, so you're bound by these rules. You're not to well, you know what you need to do and what you can't do. All right. We'll be back at 12:30 sharp to conclude the hearing.
All rise.
Yeah.
Signed off on it. The referee.
Never mind.
Court is back in session.
All right. Please be seated. All right, first let me address the issue of the witness who may or may not be testifying by telephone. The Federal Rule of Criminal Procedure, or Civil Procedure 43A says testimony should be in open court at trial. The witness's testimony must be taken in open court unless a federal statute, the Federal Rules of Evidence, these rules, or other rules adopted by the Supreme Court provide otherwise. For good cause and compelling circumstances, and with appropriate safeguards, the court may permit testimony in open court by contemporaneous transmission from a different location. So with that being the standard, Ms. Schwager, I'm not certain that the rabbi has anything to offer anyway. If the rabbi's testimony is going to be to testify about some deplorable conditions that Ms. Stone's mother is being kept in, that's not relevant to my decision here. If he has testimony that's relevant to my determination of the substantial likelihood of success on the issue that's before me that relates to due process, retaliation, etc.
Yes.
And if you can verify to me as an offer of the court that the person on the other end of the line is going to be this rabbi, I'm inclined to allow it, but I'm going to cut him off if it gets into issues that aren't relevant. So number one, do you believe that he has testimony to offer that is relevant for these proceedings?
Yes.
And can you certify to me that the person that is about to call into court, or that we're about to call, is the rabbi? That you're the same person that you are representing, you want to ask questions of?
Your Honor, I don't know his voice. I don't know that I could certify that. I know that Barbara Stone could certify it, but I can't say that I can.
Good cause in compelling circumstances. What's the defensive position? Mr. Glantz?
Your Honor, I have no objection if I guess the court can use its judgment to decide if the other person on the phone is who he says he is. My only comment would be we do have, if it's the same person, we do have an affidavit in the record in document 18, which purports to be written by a rabbi, and just to economize the court's time, a large part of the affidavit is to the effect that how certain he was that someone's rights were being violated, and so if the court can, I don't like to interrupt examinations, but if the court can just keep that out of bounds, that would be my only objection.
Well, first of all, is it the same rabbi?
Yes.
And is the testimony going to be duplicative of something that's already in the record?
I think there's a few questions that are not, so I could limit it.
All right, Mr. Lustig?
I would have the same objections as counsel, but to the extent that counsel has questions that are outside of what has already been presented and filed within the court, I have no problem.
All right, I think we're probably pushing the limits of good cause and compelling circumstances, and I'll note again that I didn't have any notice of this prior to coming to court this morning, but we're here, we have the ability to accommodate it, and I'll allow it, again, within the strict parameters that I've already told you. I don't want duplication, and I don't want testimony from a rabbi about things that aren't relevant to the legal issue that's pending before me, all right?
And specifically, Your Honor, it's document 18-1, beginning at electronic page 76 on the letterhead of Rabbi Edwin Farber.
That's Ms. Rabbi Farber that you're calling? Ms. Schwager?
I'm sorry, there are several affidavits that were filed in this case.
But is it Rabbi Farber that you're calling as a witness?
Yes.
All right. I'll allow it. It probably makes sense to do it first. Are you prepared to call him as your first witness?
Yes.
All right. Is it Debbie? Do you have a number that you can reach him at? All right. Let's see if we can set that up because our technology doesn't always work.
65.
I'll ask him about that. Answer.
Hi, this is Rabbi Ed Farber. Sorry I missed your call. Please leave me a message, and I'll get back to you as soon as I can. Thank you.
All right. We'll proceed with other witnesses, and if you're able to get them at the end, I'll reconsider whether to allow his testimony. But for now, we don't have him. So call your next witness, Ms. Schwager.
Elliot Bernstein.
Mr. Bernstein, come on up and sit in the witness chair up here.
Thank you, sir.
Please raise your right hand. Do you solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth?
So help me God. Yes, I do.
If you'd please state your name and spell your last name for the record.
Elliot, Eliot, Ivan, Ivan, Bernstein, Bernstein.
All right, Mr. Bernstein, as has happened with a couple of other witnesses, I see you've come to the witness stand with some papers or documents in your hand. You're being asked questions and you're giving live testimony to the extent you're being asked about things that happened in the past or to testify about your memory. If at any time you think you need help in refreshing your memory, you can ask to do that, but I don't want you looking at, referring to, or reading any documents unless you can't recall the answer, okay?
Yes, sir.
All right, you may proceed.
Mr. Bernstein, I want to ask you about the hearing that you attended recently on the show cause, May 4th. Do you recall that?
I do.
Did the hearing, let me just ask you this, did any of the hearing go forward?
Not that I'm aware of.
What occurred that day?
Me and my wife arrived to be a witness. Barbara asked us to come as witnesses to a hearing we attended with Judge Perlman. We got to the court and Mr. Lustig confronted us hostilely. Who are we? What are we? What are we doing there? And then a bailiff came out and asked us what we were doing there with Mr. Lustig at his side, and we said we were planning on being witnesses. He said, okay, have a seat. They then went inside. The bailiff then came out and told us that there would be no witnesses for Barbara Stone, that they were basically there to arrest her.
Hold on, sir. What's the objection?
First of all, for clarification for the court's purposes, the witnesses identified this hearing as before Judge Perlman. What the witness is testifying to was not before Judge Perlman what went on. So,
Your Honor,
for clarification, since it was he was led by counsel.
All right, to begin with, and I don't think you even laid any foundation for whether he was there. What hearing are we talking about?
he spoke of two. He was speaking of a hearing before Judge Perlman, and I would like to speak to him as well about the show cause hearing in Judge Genden's court.
All right, you may do that,
May
but
4th.
just make it clear for everyone here and for the record which hearing you're talking about, and so that we can keep this separate. Also, I should have said this at the beginning, but the rule has been invoked and the rule is still in effect, so if any witnesses are here who are potential witnesses in the case, you need to be outside. All right. So you may proceed, but again, clarify what hearing you're talking about and establish that he was there.
Did you, have you attended any hearings in Judge Genden's court?
That's what I was speaking to. I was asked to be a witness at Judge Genden's show cause hearing by Ms. Barbara Stone. And it's when I arrived at Judge Genden's court that all of this that I just testified to took place. So we showed up to be witnesses. The bailiff came back out and said there would be no witnesses allowed on Ms. Stone's behalf, that there wasn't going to be a hearing. They were basically going to arrest.
Is an objection?
Hearsay, for its truth.
It is apparently, hearsay on its face. I'm going to allow it not for the truth of the matter asserted, but for the fact that it happened and the behavior of this witness's, and this witness's behavior after hearing the statement. So I'll allow it on that basis only, not for the truth of the matter. You may proceed.
So the bailiff came out and told us there wouldn't be a hearing, that that Barbara wasn't, that they were going to basically arrest her if she showed up, and that I had to leave the building. And so I said, well, you know, the other side has a witness. They had a Miss Lapidus. And they said, this is the judge's order, you have to go. And what was most frightening was we showed up there, and when they said that they were going to arrest her, they had a posse of people that were waiting to arrest her. It was kind of intimidating. It wasn't like showing up to this court. There were actual armed people outside with restraints, and it was
a posse right back there in a blue coat.
Well, that's a friendly-looking posse. This other posse was there to make an arrest, it appeared. That they weren't even going to let her in the door. Mr. Lustig was abrasive to both me and my wife, demanding who we are and what we're doing, and I felt very uncomfortable as he was attacking us.
All right, Ms. Schwager, let's get a question.
Okay. Certainly. Did the bailiff shut the door and not let you in the courtroom?
Never stepped foot in the courtroom.
And you learned or you saw that Blair was there? Blair Lapidus?
I saw her and had known her from Judge Perlman's hearing.
Okay, and were you ever told why you should leave the building?
Yeah, because there was going to be Barbara wasn't going to have a hearing. There was going to be no witnesses, and that if she showed, she was getting arrested.
Okay. Have you, there's been some allegations by Mr. Lustig in this case that to the extent that this lawsuit is somehow frivolous. And can you tell me, how well do you know Barbara Stone?
I know her very well. She's been a guest at our house and stayed for weeks at a time. So I know her pretty well, know the case pretty well.
And you're aware that there were multiple other lawsuits that were filed?
Correct.
Do you have any understanding as to what happened and why those were filed?
Objection, personal knowledge, irrelevant.
I'm sorry, withdrawn.
All right. If you're going to ask questions about what he knows, give me some idea who Mr. Bernstein is.
Okay, sorry, but
I see him here, but I don't know who he is.
Okay. I'm sorry. Can you tell me how you know Barbara?
Yeah, I know her through victims' rights groups that she's a member of. She contacted me to speak to a group of attorneys about RICO-oriented public corruption lawsuits, which I spoke at. And then we became friends, and I began looking at her case in relation to some of the other kind of public office corruption cases that I'm involved in.
And you have spoke of that. What is your experience, if any, in legal or in this area of law?
Just personal experience. I'm representing myself pro se in a case in West Palm Beach, where it's led to the arrests of
Irrelevant.
law firm members.
Where are we going? I mean,
Just, yeah, that's all, that's sufficient.
all right,
I
objections
just,
overruled.
all I wanted to know is essentially, are you familiar with, are you following, I'm sorry, have you reviewed pleadings in this case?
Yeah, I've reviewed pleadings in this case and the other cases she's filed, and
Object irrelevant.
Do you have any opinion? Your Honor, I'd just like to
One person at a
answer,
time.
I would just like to answer to his allegations of the vexatious litigant, and Mr.
That's-
Bernstein has limited testimony that he could provide on that, and that's all.
If you're in some sense trying to qualify him as a legal expert to give me
No.
advice about the
No,
legal
no,
staff.
no.
all right,
No,
then what-
no, and I can withdraw that question. I was just trying to,
The question so far is fine. The question so far is, are you familiar with, have you read the documents?
Mhm.
But I'm concerned about the next question. Are you going to say, do you think they're frivolous? If so, that's objectionable. That's an ultimate issue for me, and I don't need an expert to tell me how to rule.
okay.
So where are you going with it?
I'm just going with more of a basis behind what's going on, and
You're asking him to vouch for the basis for pleadings that Ms. Stone's filed?
no,
That's going to be objectionable
he
as well.
stated that Barbara has spent weeks at a time with them, and I guess I'm more going in the direction of Barbara's intent in doing this and why she's doing this.
How is that going
He's
to be?
accusing her of being vexatious. Judge Gennen's asking you to find her a vexatious litigant.
Seems to me Mr. Bernstein's opinion is either going to be based on a review of the documents, in which case it bleeds into the area of a legal expert, which is not appropriate in this case, or it's almost necessarily going to be based on what Ms. Stone told him, in which case it's hearsay.
No, and I can withdraw that question. I'm getting at something else entirely different. I'm sorry if it's
All right.
not clear. I'm just
Well,
essentially that.
let's do this.
Okay.
The objection to the immediate question is overruled. There's nothing wrong with that question. I just told you a couple of
Yeah.
areas that I'm going to sustain objections to, but I'll leave you to walk that path, and if you have some testimony coming from this witness that is admissible and relevant, then let's elicit it.
Do you have any opinion as to, have you observed the effect that this litigation regarding Miss Helen Stone has had on Barbara?
yes.
Hold on. There's a multiple compound question. Are you asking his opinion? In which case,
I'm just
I'm
asking.
expecting an objection that would be sustained. Are you asking him if he has observed her filing pleadings? What is the question?
I'm asking him if you've just observed her emotional state and what it's been. He doesn't have to be an expert. I'm not asking for an expert opinion, just a factual.
A question about having observed her emotional state will be allowed.
Objection, Your Honor. Her emotional state at what period of time?
Within those parameters.
Have you observed Miss Barbara Stone's emotional state during the times that you said she stayed with you for a couple weeks at a time?
Yes, I have, and it's been during these stressful pleadings that she's been filing. She's been up all night working. She doesn't do anything but work on this, meaning she's in a emotional disarray over the fear of her mom dying. It's hard to sometimes ground her to calm down a little bit about it. These pleadings she's filed all look like pleadings of love. I don't see her looking for money. I don't see her looking for anything but to help her mother. And I can only say that if that was my daughter fighting for me and I was in a situation like this.
Objection irrelevant.
Objection is sustained as to relevance.
Do you believe that that Barbara's fear of being arrested again is reasonable?
Absolutely.
Objection is sustained.
Or you should, let's see. I guess that's, I want to ask you about Perlman hearing. There was some talk earlier, and I think you were here when the judge asked about the statement that the judge made when she said that I admittedly misinterpreted. Do you recall hearing that statement when you were there? You were there, is that
I did.
correct? Were you at the hearing?
I was at the hearing. Oh, what'd you say?
No, well, there's no objection that is sustainable to the question, were you at the hearing? But did you have another objection, Mr. Lustig?
Yes, Your Honor. Can we again just clarify? We've gone across the board now. What hearing? What was the hearing for?
I think we're now at the Perlman hearing, correct?
Yes, the Perlman hearing, and it was,
Okay.
I think you
was
don't
in
need...
the, I think it was a
That's okay.
emergency
There was only-
request for an independent medical review of Helen Stone by Barbara Stone.
Objection. 1 second. Your Honor, is that a question? I didn't.
Yeah.
It's not a question. You asked me what the hearing date was.
All right.
It was April 21st, 2015, in front of Judge Sandra Perlman.
All right, I think we have it identified, and so you've asked the question whether he is present at that hearing. The answer was yes. Go ahead at your peril with your next question. If you want to
Do you
reopen the
recall-
issue that we started up with,
Did you feel like that Judge Perlman was sympathetic, overly sympathetic to Barbara?
Well, I think the point...
hold on, Mr. Bernstein, I think there's an
Yes, sir.
objection.
The Judge Perlman hearing, as we're calling it, is entirely irrelevant. Her remark, the best evidence of the hearing is the transcript, but more importantly than that, that court's remarks about the face of a pleading are immaterial to anything that's before this court today.
Yeah.
Sustained. Again,
Yes,
unless
that's all.
you are intending to reopen the issue that we led off the hearing with and withdraw your contention that it was a misleading statement in your pleading
No, no.
and you're sorry for it, if you want to try to convince me that that the transcript is wrong and that this witness has a better recollection, is that where we're going?
No.
That's a whole different issue.
No, sir.
All right, where are we going then?
There's a disqualification that was filed, and that was all I wanted to talk to him about, is his perception of, whether the judge is fair or not. They went to one hearing.
You can ask that question. As phrased, it's objectionable. A moment ago, did you feel that the judge was overly sympathetic to Ms. Stone, I think was how you phrased it. If you're asking for this witness who was present at the hearing, his impressions of the way the judge behaved or the way Ms. Stone was treated, I will allow the question in that limited area, so you may proceed.
Question is that when you were at Judge Perlman's hearing in April, what was your perception of the way the judge treated Barbara and Mr. Lustig?
It was the impression of the hearing was 100% opposite of the hearing for Judge Genden. It was warm, receptive. She listened. And then when we got the disqualification that Mr. Lustig filed, it said that he was asking for the disqualification of Judge Perlman based on that she had
Objection,
prejudiced.
Irrelevant as to
Yeah.
what
That's
is going
fine.
way beyond again.
It's sustained. This is
It's-
irrelevant.
okay.
Why are we talking about, there are...
It's
Let me
one of
finish.
the allegations that they have made.
Let me finish.
I'm sorry. I didn't realize you were talking.
That's part of the problem. There are allegations that a particular judge, Judge Genden, has behaved in an inappropriate manner. That's what's before me. Whether a different judge in state court, federal court, bankruptcy court, anything else, treated your client better than another judge is absolutely irrelevant to my decision. If that's the purpose of this witness, I think you need to rethink the witness. If you've got a legitimate reason for calling him and have legitimate questions that pertain to the specific and discrete issues that are before this federal court, you may ask them.
Judge, I believe that, I believe it's going to be too hard for me to get the answer out that I need, so, yeah, I'll rest, thank you.
Thank you.
You rest or you're finished with this witness?
I've been for the witness,
All
I'm
right,
sorry.
any cross?
Yes,
All right, first, Mr. Glantz?
just very briefly.
Okay.
Mr. Bernstein.
Hold on,
you-
Mr. Lustig. I think Mr. Glantz said he had some questions.
I'm sorry.
You
I
can
said I-
go in a different order if you
Oh.
want to, but I'm trying to keep things orderly.
None.
Go
I
ahead.
said no.
Oh, I thought you said just
He's
briefly.
not going to let me. I mean, you're...
All right, then go ahead, Mr. Lustig, my mistake.
I'm sorry. That's all right. Mr. Bernstein, On that particular day that you testified as to being present at the hearing for Barbara Stone, was Barbara Stone present?
Which hearing?
Well, you testified only to one hearing in reference to Barbara Stone being before Judge Genden.
At the Judge Genden hearing.
Judge Genden hearing.
Yes, and what was your
Was
question?
Barbara Stone present?
No, she wasn't, that I know of.
In fact, you knew she wasn't coming, didn't you?
No. In
No?
fact, I thought the opposite. as
You
I
thought
told
she was
that
coming?
day.
Don't
Yeah.
talk over each other,
Okay.
please. Ask the question.
I apologize.
And wait for the answer.
All right. Did you see any attorney for Ms. Stone at that hearing?
I did not.
To your knowledge, did Ms. Stone have an attorney at that hearing?
My knowledge before or after?
At any time, to your knowledge, did Ms. Stone have a hearing?
Yes.
She had an attorney at that hearing?
She did.
Okay, and who was that attorney?
Candice Schwager.
And did Ms. Schwager attend by phone, or did she attend by person?
Objection, lack of personal knowledge.
If you know.
If you know.
Overruled.
Well, I know by reading the transcript.
If you know by your attendance at the hearing whether Ms. Schwager was not based on reading on some document at a later time. If you
I
know
was
based
not allowed in the hearing. It was a closed
All right, so,
hearing. So I guess the answer is no.
okay.
All right. You stated, for the record, that there were witnesses that were allowed to be in the hearing. Is that correct?
Yes,
Other than yourself.
correct.
And what witness is that?
Blair Lapidus.
Are you aware that Blair Lapidus is the guardian of Helen Stone?
I am.
Okay. Are you aware of the fact that Blair Lapidus, as the guardian of Helen Stone, has the right to be present there, and that her presence is on behalf of Helen Stone?
I believe so.
Okay. So in fact, she wasn't allowed in just as a witness where you weren't, correct?
Well, when we asked the bailiff, he said she was allowed to stay as a witness. We weren't, so.
Okay. But
That's why we
that's
did it
the
that way.
extent of your knowledge as to who went in and as far as a witness is concerned, correct? Okay. I have no further questions, Your Honor.
Any brief redirect?
Yes. Was Mr. Lustig allowed to stay in the hearing?
Yes.
No further questions.
All right, thank you, Mr. Bernstein. You may step down.
Thank you, sir.
Any reason he can't stay if he wishes to? He won't be recalled by either
reason.
side? All right, call your next witness.
Robert in here. Robert, Strahan? I think he's outside. Strahan? Strahan? Robert Strahan? Sorry. Sorry.
All right, Mr. Strahan, is it? Come on up here. You're being called as a witness. Come on up to the witness stand.
Please raise your right hand. Do you solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth? Please have a seat.
All right, Mr. Strahan, come on up and state your name and spell your last name for the record, please.
Dr. Robert Sarhan, S-A-R-H-A-N.
All right, Dr. Sarhan, I notice you've come up with some documents or papers. Let me remind you that you're being asked questions here today for live testimony. If the questions are asking about your recollection of anything, then you're to testify based on your memory. If at any time you feel like you need to have your memory refreshed, you may ask permission to refresh your recollection, but I don't want you testifying from documents. You understand?
Yes, Your Honor.
Okay, you may proceed.
Mr. Saran, thank you for coming today. Could you tell me a little bit about your background?
I went to University of Florida for undergrad. I went to medical school at University of South Carolina School of Medicine. I returned back to Miami, Florida in 1992, where I worked at Jackson Memorial Hospital for 4 years. And then I went and worked for the Department of Justice, Federal Bureau of Prisons for the remainder, for the last 13 years.
And the last 13 years you worked as a doctor in the
I
prison.
haven't worked for them in a while, been 7 years, but I worked for the Department of Justice Federal Prison for 13 years. Yes.
In what capacity?
As a physician.
Do you know Helen Stone?
Yes, I do.
How do you know her?
I met her quite a few times visiting her in a nursing home facility.
Did you visit with Barbara? Or?
Yes.
And are you familiar with her, I don't want to go into what it is, but with her medical condition?
Yes.
Objection.
Do you,
Not objectionable so far, but it's getting close.
Well, I want.
do you feel that,
Hold on.
With the court's permission, Florida statute 456.057, small 7a, and I quote, "The medical condition of a patient may not be discussed with any person other than the patient, the patient's legal representative, or other healthcare practitioners and providers in the patient's care or treatment, except upon written authorization from the patient." So any discussion of the medical condition of a person who's not before this court, I think is protected.
Your Honor,
Schwager?
I believe he's reading part of the HIPAA regulations, and they're only...
Florida statute.
I don't know if that's a reference to the HIPAA regulations, because I'm not able to research it at this very moment, but my understanding is, for instance, HIPAA privacy regulations, I've researched the issue and I confirmed it, that it does not apply to, it only applies to medical professionals. So if that phrase were to be read in the context of a medical professional who you could talk to about it, then it seems like it would make sense and be consistent. But I'm not representing that that's what it means, the phrase he says, but I'm of the opinion that he's alluding to a HIPAA-related regulation. And Doctor, do you know any...
Don't ask him a question. Number one, you've just established that he is a medical professional. But before we even get to the issue of whether this violates any privacy laws or privilege, we're not going to go into Ms. Stone's medical condition. That's not what we're here for. So why is this witness being called?
Because
why don't you proffer that to me?
He was there the day that Ms. Stone took her out of the facility, and he saw her, and he saw her condition, and he can speak to it because he's a physician.
We already precluded defense counsel from going into those issues because of privilege and because of HIPAA regulations, and because, more importantly, from my point of view, it's not relevant. What's relevant on that day is that Ms. Stone went and took her mother out of the facility, and whether that was in violation of a court order. The medical condition is not an issue. We're not entertaining that. I'm not going to open up a guardianship issue. I'm not going to make any rulings or even consider any evidence about Ms. Stone's mother's health. Are we clear on that?
Yes, and
then why is this witness being called?
Just simply because he was a witness that day. He was there, and
he can testify to the events, but I don't want him testifying about the health condition of Ms. Stone's mother or anyone else. Clear?
Yes.
Does that satisfy your objections?
Yes, Your Honor.
All right, go ahead. Be careful.
Did you see Helen Stone the day that Barbara took her out of the facility?
Yes.
Would she willingly go, or do you know?
Oh, yes. She was smiling and very happy.
Have you ever been in Judge Genden's court?
Yes.
When?
Oh, last year.
Did you get to observe, you had mentioned an event to me, and was it connected to Barbara's case?
Yes.
What happened?
Barbara asked me to go to court with her. So I went to court with her, and we both walked into the courtroom, and Judge Genden said, "What is he doing in here?" He was actually screaming.
Objection. Judge.
What's the objection?
What hearing were we speaking of? What date?
Sustained. Ms. Schwager, set the table for us. What hearing are we talking about?
It was this 2014, 15?
2014.
Do you recall the date?
I don't remember the exact date. Okay, Barbara would know that better than me. She asked me to go to court with her quite a few times, Your Honor, and I've gone to court with her all the time, whenever she asked me to.
If you don't know the date, what was the purpose, or Ms. Schwager, you asked the question.
Okay.
But
Do you recall
we need to know which hearing this is.
Yeah, do you recall what the purpose or the substance of the hearing, what it dealt with in general?
On that particular day, I think it had something to do with her seeing her mother, that she wanted to see her mom.
Did she have a lawyer at that hearing?
Excuse me?
Did she have a lawyer at that hearing?
No, she went in, it was just me and her.
Okay. Just to make sure, was this any kind of show cause hearing for contempt or something that she was afraid to go of? Or?
No, I don't remember exactly, because we didn't get a chance to sit down. Judge Genden screamed at me and told me to get out of his courtroom. And he just got like in a violent rage when he seen me in the courtroom. And I mean, it wasn't a courtroom, sir. It was just a chambers. It was a very small chambers. It wasn't a courtroom. It was just a very small room, and with his desk at the end. And so I just went in there, and I didn't even get a chance to sit down. He started screaming very loud, "Get him out of here!" And so I walked out of the courtroom.
Hold on, please, what's the objection?
Objection.
Hold on.
First of all, relevancy. We haven't established what the doctor was there for.
Yeah, Ms. Schwager, I mean, now it sounds as if he walked into chambers and was not welcomed with open arms.
No,
I assure you
that
I was
wasn't my
treated the same way.
understanding.
Is this a hearing that, even if he doesn't know the exact date, we've talked about numerous hearings here in front of different judges. You need to establish what hearing it was, whether it was a scheduled hearing, and what the reason for the hearing was, and why this doctor was there. And and even then it may not be relevant, but let's at least establish so that counsel and I can understand what you're talking about, roughly when, where. We know it's Judge Genden, but again, was it a scheduled hearing, and if so, what for?
Yeah, I mean, I
Ground us
don't
a little
know
bit.
if this is something you want to even hear or think is relevant. You were speaking of
Those are two different
misconduct.
things.
It's more about an attitude and the hostility between, the credibility of the witnesses and the tone of what's going on, because
I understand what you want him to say, the testimony you're eliciting, and it's not a matter of what I want to hear and what I don't. It's got to be relevant if I'm going to hear it. And if you're going to say that at some unknown time, some unknown place, for some unknown reason, Judge Genden lost his temper, I'm not sure that's relevant.
No, I
If you
didn't
can establish this as a judicial proceeding that we've already talked about, or a new one, then establish that. But how can defense counsel be expected to cross-examine when they don't know when, where, or what the purpose of the hearing was?
I think
Counsel asked the questions.
I'm sorry.
All right.
Do you recall when or what the purpose was?
I'm not 100% sure, but I think it was around February 2014.
Okay. And why were you there?
I was there just to give support because Barbara was scared to go in the courtroom by herself, so I was there just to give her support.
And did you know, why was Barbara scared, to your knowledge, to go to the courtroom?
It's a very hostile courtroom. Judge Genden doesn't like her.
Irrelevant.
Hold on, please. Wait for the objection to be ruled on.
Object irrelevant. I think this is far away from any of the material issues before the court. The witnesses opining about how other people felt, how they appeared, their demeanor. I don't see any materiality to the legal issue.
I agree, and I haven't seen this tied up to any hearing that we've heard about. The witnesses talked about going into chambers where the judge was sitting at a desk. We've heard nothing about anything like that as far as I know. If he has relevant testimony about any of the hearings that Ms. Stone or anyone else has testified about that are the subject of the case that's before me now, then you may proceed. Otherwise, you're going to be finished with this witness.
Yeah. Can you tell me, have you worked with, what is your experience in this area of law as far as, you had wanted to, do you have any experience in the guardianship?
Absolutely. I have. I've been featured in many news articles. News articles around the country. I spoke in Congress. I spoke in the legislature. I
Check the
spoke with
material. Is this a foundation for expert testimony? If so, I object.
I'm I'm not,
First of all, let me also say for the record that the witness was holding up a copy of the DVR, but that I was not able to see it and hasn't been offered. If you give him background on who he is, that's fine. If
That's
you're offering him, going to offer him as an expert, tell me that.
no, sir.
But
It's not
we
as
were-
an expert, I just, in general observations, that's all. It's a pretty short question. He's got a lot of experience in probate courts.
all right, you can go briefly into his background, but only to the extent it's relevant to whatever testimony you're trying to elicit. And is it anything more than what we've already heard, that Judge Genden lost his temper?
No, I believe it's more.
All right, go ahead.
Okay. We're speaking about your experience in guardianship.
Yes, it started in 2003. My mother was forced into guardianship against her will when she was fully competent. I fought for my mother for 7 years until she was murdered with a drug Seroquel.
Objection, Your Honor.
Sustained.
And I just want to kind of really sum it up. Is in your experience in going to these hearings with Barbara in Judge Genden's court, is it your standard? Is it just a regular court hearing and where there's no reason to be concerned, or is something occurring that the court should know about that would cause them concern?
Yeah, if I may elaborate just a tiny bit, Your Honor, I can be very brief if you please. I've been doing this since 2003. I've been involved in hundreds of cases throughout the last 13 years.
I'll overrule it. I think I see where he's going. You can talk about, if you're talking about your experience in courts in general, in order to compare it to what you observed here, you may lay that foundation. Go ahead.
Yes, sir. Actually, I don't know if I'm allowed to just hold these things up, but they're basically, I'm showing the judge documents that go back 30 years from Congressman Claude Pepper, where he wrote, "Guardianships in America, a national disgrace." And I have done extensive research, speaking with congressmen all over the country about the abuses of the elderly in guardianships. Congressman Claude Pepper wrote abuses in
Objection is sustained. I said I would allow you to give the limited testimony, if this is where you're going, about your experiences in court as opposed to the behavior of Judge Genden. You're not here to talk about the history of elder abuse in the United States.
Yes.
So ask a question that is designed to evoke a relevant answer. Ms. Schwager.
And that's, I apologize, that's all I'm seeking is to ask you, is there anything different about the hearings that you've been to in Judge Genden's court as opposed to the other courts that you've been involved in the last 13 years?
It's a very hostile court. Like I said, I'm not quite sure if I'm allowed to answer what I was trying to answer, but Judge Genden chased me out of the courtroom. I said not one word, and he chased me out of the courtroom, and he almost hit me. He put his finger in my face, and the police had to stop him. And I was going to the elevator. He said, "Leave his courtroom." I got up. I didn't sit down. He said, "Leave his courtroom." I walked out. I didn't say one word. I walked out, and I was walking to the elevator, and right before the elevator, right before you leave the entrance of that room, he came up to me and started putting his finger in my face, and the police had to stop him. And I tried to I couldn't walk because he got in front of me, and he was like in a violent rage. I never said one word to him. He said, "Don't you ever come in my courtroom again," and he was screaming at me at the top of his lungs.
All right.
And I feel that he's just, out of control. Like I said, I've been in many, many courtrooms over the last 13 years. I've never seen anything like this in my life.
All right, thank you. Any other questions?
No.
Any cross?
Cross.
Mr. Glantz?
Are you currently licensed to practice medicine in the state of Florida?
No, I am not. I was practicing in the Federal Bureau of Prisons. That's where I'm retiring from.
You are not a licensed physician in Florida?
No, sir.
No questions.
Mr. Lustig?
Brief.
You've said that before.
I know, I apologize again. Doctor, you've stated on the record that you were a physician for the Department of Justice and Prisons, correct?
That's correct.
Was that your title with the Department of Justice and Prisons?
Well, that's a mistitle. I was titled as a physician assistant, but I never went to physician assistant school. I am a physician, a medical doctor.
That was not my question.
That's the answer.
You were not a physician with the Department of Justice, were you?
I was.
You were hired as a physician with the Department of Justice?
The only training I have is an MD. To be called a physician assistant, you have to go to physician assistant school.
Were you hired as a physician with the Department of Justice?
Your Honor, objection, relevancy, we didn't go into any expert testimony.
I'll allow, as far as it's going, I'll allow, because you did ask about that much of his background, and if that's being called into question, I'll allow Mr. Lustig some latitude. Go ahead. And let me remind you both, don't talk over each other. Go ahead, Mr. Lustig.
Were you hired as a physician?
No, I was hired as a physician assistant, but I was a physician, and we tried to fight this in court. Many of us around the country tried to fight this in court, and
Your Honor, it's a yes or no question.
No, it's not. No, it's not.
It's a yes or no question. You can explain.
Okay. No, I am a physician, not a physician assistant.
Okay. Doctor, were you dismissed by the Department of Justice?
I was.
Okay, and you were dismissed for what reason?
For accepting, well, it's in federal court right now, so the decision's gonna be overturned, and I was for accepting legal advice from a prisoner, but nobody knows what advice it was.
But let me ask you, Doctor, in fact, did you not write a letter to a district court, U.S. District Court judge, attesting in the letter that you were a physician for the Department of Justice?
Yes, I am a physician.
Okay. That wasn't the answer to my question. I asked you a specific question.
Yes, I am a physician.
And did you not sign a letter to a U.S. District Court judge stating that you were a physician with the Department of Justice?
I signed it as my title, which is Robert Sarhan, MD. That's my given title. I earned a title.
All right, thank you. Doctor, let me just ask you, the hearing that you were describing to the judge in respect to Judge Genden and how you were treated, was I present?
I don't remember.
You don't remember that I was present at every single hearing?
Well, if you were on the other side of the table. I didn't get a chance to sit down. I walked in the courtroom, and then all of a sudden Judge Genden started screaming at me, and I walked out.
Well, do you recall Judge
I've seen two police officers in there, but I don't know if I remember seeing you.
Dr. Sarhan, please wait for a question.
Yes, sir.
Do you recall, strike that. Do you recall Judge Genden asking you what you were doing there?
No, I don't remember.
Are you aware of the fact that guardianship hearings are typically closed?
That's not true. Guardianship hearings are not supposed to be closed, only if you're talking about the medical problem of the person, and so that's not true. Every court is supposed to be open, and the elderly person should be in the courtroom. That's the law. The elderly persons are never in the courtroom, and that's what we're trying to fight and stop, Your Honor.
Mm-hmm. Are you aware of the fact that the Florida statutes allow a guardian to waive the presence of a ward depending upon the ward's mental and physical capabilities?
And that's what I'm trying to stop, and that's why I'm advocating.
I just asked you, please.
Yes or no question.
Your Honor, sometimes it's very difficult to answer yes or no, and I can tell you why if you give me a chance.
I think you had an implied answer because you said that's what I'm trying to change. The question is it...
Yes, it's true, but it's not true. If I can explain, but I want to be able to explain.
Listen to me,
It's
Doctor.
really not true.
Listen to me.
Yes, sir.
In general, Mr. Lustig is going to be asking you yes or no questions. You answer them yes or no. If you feel a need to explain, you can ask permission to explain.
Yes, sir.
And in some circumstances, I will allow you to do
Yes,
so.
sir. Yes, sir.
But first you have to answer the question if
Yes,
you know
sir.
the answer. So
Yes, the answer is yes, but I'd like to,
all right.
I'd like to,
The answer to the question is yes?
the answer to the question is yes, but I would like to.
You may explain.
Yes.
Go.
Yes, sir, thank you. Your Honor, thank you. What's happening is here, Your Honor, that competent elderly people are being ruled incapacitated,
Objection.
then being stripped of their civil rights.
Hold on. Suggestion.
Irrelevant. The witness, whatever he's trying to change in the rest of the country, it's immaterial. This is a factual bound inquiry.
Sustained. Doctor, I'm allowing you to explain certain things if the answer is unclear. But it's Mr. Lustig's examination. He's going to take you where he needs to go. If you don't like the status of the law, then I may or may not allow Ms. Schwager to ask you about that on redirect. But that's not really an explanation of your answer. The question has been answered, and we're moving on.
Your Honor?
Yes?
Can I just say one thing? I was trying to finish, but I was stopped. You're
stopped by me because I sustained the objection.
Yes, Your Honor, but I didn't get a chance to finish the
And you're not
answer.
going to. When I sustain an objection, you
Because-
stop answering.
Yes, sir. I understand,
All right.
but it's something very important that I wanted to say about the answer.
Doctor,
Yes, sir.
it's my courtroom. When
Yes,
I
sir.
sustain an objection, the witness
Yes,
doesn't
sir.
answer. Do you understand
I'm
that?
sorry. Yes, sir.
Go ahead.
Doctor, you're not new to litigation, are you?
Well, I'm not a lawyer, but I sometimes had to represent myself.
And in fact, you, like Ms. Stone, have brought a federal case against a sitting judge in Miami-Dade County in the probate division, didn't you?
Objection, relevancy, inflammatory, the prejudicial value is outweighed by the probative, the probative value is outweighed by the prejudicial, what relevance is this?
This goes to credibility. It's overruled.
Yes, I did.
Okay. And if I recall, the style of the case is Sarhan versus Rothenberg. Is that
Yes,
not
right.
correct?
Yes.
And you likewise brought the same type of action against Judge Rothenberg concerning a pending guardianship of your mother regarding you and other siblings that went on before Judge Rothenberg that you brought to the federal court, correct?
I believe I only took one case. It was a writ of habeas corpus petition. That was only one case to the federal court for Judge Rothenberg.
You sued Judge Rothenberg individually as well, did you not?
No, I was one case I filed.
Yes,
in
it's
federal
one
court.
case, that's correct.
Right, yes, I did.
Okay, all right. And what happened to that case?
I didn't get a chance to answer in a certain time. The case was dismissed.
And there was no ruling by the court in respect to your pleadings, are you saying? I asked you to try and refresh your memory.
Hold on. I never went into the courtroom. It was all done by paperwork. I never got a chance to bring my mother into the court, which that's what my goal was. So they ruled, I think, but we never had a hearing. So at that time, I was fighting for my mom's life, and I just don't remember everything. It was a long time ago, and I was trying to get my mom out of the guardianship to save her life.
Right. You had siblings, correct?
No, I have one sibling.
With a sibling, right. And there were issues with you and your sibling concerning your mother?
No, sir. No. Well, my brother brought the case into the court, but my mom wanted to be with me.
Right. So there were issues between you and your siblings, correct?
Yes.
All right. And in fact, if you recall, if you just think back, the court did render an order in respect to your pleadings and the counts that you brought against the judge, correct?
Be honest with you, I really don't. I mean, if they did, but I don't remember because I thought that the case was dismissed, but I don't remember.
Yes, the case was
I just
dismissed.
remember that somebody wrote that I was a disgruntled litigant in the newspaper or something, and I'm not a disgruntled litigant. I was trying to save my mother's life, in which I did not. She died.
Okay. So the answer is you don't remember the
I just
circumstances.
didn't remember, Your Honor. It's been like 8 years ago, so I just don't remember.
All right. Any further questions?
No further.
Any brief rebuttal? I mean, not rebuttal, redirect?
No.
All right. Thank you, Dr. Sarin. You're excused.
Sorry, Your Honor.
No need to apologize.
I tried, but...
Thank you for your testimony. You're excused. Any further evidence or testimony?
One more witness. Mr. Lustig is a pro se defendant in this case. I'd like to call Mr. Lustig briefly.
A pro se defendant in this case you're calling as a witness?
He's representing himself pro se. He is a defendant. There's not just a lawyer, is my point.
Oh, Mr. Lustig. I'm sorry, I thought you were calling him as a witness?
Yes.
Mr. Lustig? What's your position on that?
Well, in respect to calling me as a witness, Judge, I am a pro se litigant defendant in this case. In respect to anything that she may ask me, in respect to the case, my clients, it's going to be attorney-client privilege. So I don't know what she's going to ask me until she asks me. But for the most part, I would probably suggest to the court it's going to be attorney-client privilege.
Give me the letter.
Ms. Schwager, what's the reason for calling?
About 2 documents to ask him about and a couple questions about sworn documents that were filed.
Well, to the
Filed by
extent...
him?
Filed, yes, they were filed by him on behalf of the guardians.
Well, then that would be attorney-client privilege, Your Honor.
Why don't you go into the substance?
To the extent you're
I
seeking...
have 2 documents, I'm sorry.
To the extent you're seeking to call him as an attorney for someone who was involved in the case, I'm not going to allow you to do that. I'm going to allow him to assert privilege. To the extent you want to call him as a pro se defendant and take your chances asking him about his own involvement, you may do that, but I'm not going to allow you to question him regarding anything related to attorney-client privilege matters between him and his client. So, do you still want to call him?
I really just have one.
And if there's a document you want to put into evidence, why don't you ask him if he has any objection to it going into evidence unless it's already there. But I don't see a need to call him as a witness. So, Mr. Lustig, do you know what document she's talking about?
Your Honor, there are 7 volumes of documents. I have no idea.
Why don't you talk to Ms. Schwager and see if it's...
You want to show me what you want?
It's a letter that you wrote to the rabbi. Do you remember that? I'm looking for it. There it is.
No, I think there's several other things. Can we take a break for a minute?
You can't take a break. We're trying to get through this. Can I take just a minute or 2 to find this document? I'm looking for it, and it was in my folder.
It seems unlikely I'm going to allow it anyway, but is that your last witness, or do you want to give another shot at calling the rabbi?
Patty Reed in the back.
Is she here?
She was here.
Okay, I have one more witness, and that's all.
Am I released?
Here's the letter. I think, no, wait, it's not. Just a minute, I'll find it.
We need to talk about the guardian.
And this. I can just ask him about it. I don't have it in front of me.
No.
Why don't you ask him about it as an attorney to attorney? If it's something, if it's a document that you jointly agree should be submitted, then do it. I'm disinclined to have him called as a witness because it's almost certainly going to get into attorney-client privilege
This is
matters.
not attorney-client, but it's a document. It's a letter that you wrote to the rabbi telling him that he could not visit anymore. Would you stipulate that that's just admitted? That it's a letter that you wrote.
What?
And why don't
Just to admit it, though, I don't
why
have
don't
to
you
ask
speak
you.
privately among yourselves so that I don't hear everything you're talking about?
Please take a minute.
It's just a letter that you wrote.
Take a minute.
You want me to ask you about it?
Show me the letter.
Can you take a minute?
No, we can't.
Ms. Schwager, if you don't even have a letter,
No, I don't.
then let's move on. Do you have any other witnesses?
Patty Reed?
Patty Reed?
Yes.
Can you make
Yeah. I mean,
What do you want?
yes.
Elliot Bernstein. Good afternoon, Your Honor.
Good afternoon.
I'm Sheldon Zipkin. I represent Edward Bernstein, who is the individual who operates the facility that the ward is presently at.
For what reason are you addressing me?
He was subpoenaed to be here. I came in instead, and I believe she's going to release him now for the subpoena.
Yes.
Oh, okay. All right, thank you. Bernstein's lawyer.
How do you read that to David? I saw it.
Can I hear?
How do you read that to David?
Take a break for a while.
The pleadings.
Yes, please take a break.
No.
This is another side.
No, but
Is she here?
Your Honor, I'm wondering.
You're not addressing the court. You have a
Can I
lawyer.
confer with my attorney for
You may. You may not address the court. Speak with Ms. Schwager, but if you don't have a witness available, then we're going to move on. So talk to Ms. Stone, and then let me know what you want to do.
Thank you, sir. Thank you.
I don't have another one.
Oh, I was looking for stuff. Okay, thank you.
Your Honor, I believe we were finished.
Okay. You rest?
Yes.
Any evidence, testimony, or anything else to present by the defense lawyers? Mr. Glantz?
None on behalf of Judge Genden.
Mr. Lustig?
None on behalf of the defendants, Your Honor.
All right, that'll wrap up the evidentiary hearing. If the parties want a very brief, and by that I mean less than 5-minute opportunity to sort of a summation of what happened here today, an opportunity to address me, you may do that. Does either party wish to do that? Or do you want to rest on your pleadings?
I'll take less than 5 minutes if the court pleases.
All right. Oh, well then, if at least one person wants to do it, we'll do it. Ms. Schwager, do you wish to address me? Regarding what's happened here today and last chance to...
Yes, Your Honor.
All right.
You know, as you mentioned, this is extraordinary relief, but this is an extraordinary situation. And Ms. Stone will be arrested. I mean, probably not immediately, but imminently, certainly. The writ of attachment has issued. It is not a valid order. The law in Florida on blocking somebody from filing a case is the vexatious litigant law 3.840 of the Florida statutes, and it's supplanted the common law. And what it says is that a person who has, I guess, like probable cause sort of thing, is believed and who has filed 5 or more lawsuits has the criteria, but it says that pursuant to Article 1, Section 21 of the Florida Constitution, which is the open courts provision, that the statute only allows a bond to be paid. It does not allow that somebody can't file. It doesn't say anything about being a pro se plaintiff not able to file. And if you look at the circumstances surrounding the writ of attachment that we currently have issued, you'll see that it was complete setup. I mean, the judge issues a show cause order and says in that order that you have a right to counsel, but then he doesn't honor that right. He doesn't even hold a hearing. He doesn't even hold a hearing where testimony is given, even though he had Blair Lapidus and Roy Lust against Chambers, and he could have put on the record, he could have made a record. There's nothing on the record. He got angry and summarily stopped the hearing. I mean, we appeared, and we tried to appear as best we could. It was an emergency situation, which we described. And in fact, Barbara was before a federal judge with a TRO is the reason she wasn't there.
But this writ of attachment that's out there is simply, it's the equivalent of a bench warrant, right? Requiring someone to bring her to court so that he can have the hearing to determine whether, isn't it a rule to show cause hearing?
It is very different. It is it says order show cause, but some of his orders say appear for arraignment. And, I mean, he's not a criminal judge anymore, used to be, but a couple of these orders actually say appear for arraignment, and I'll be happy to submit them in court. But every time, he took notice of the file, essentially. He didn't have a hearing. There were no hearings.
Well,
And so
when he tried to have a hearing, she wasn't there, right?
this hearing, but the thing is, the order itself was invalid because you can't, the order violated the law, it violated the Constitution. I
Which
mean, that
order?
specific provision of the Florida statutes, 3.840, it states these specific means by which you have to go, and in fact, you have to have a hearing before you can deem somebody a vexatious litigant and just say that you can't file anymore. But no hearing occurred for that either, and in fact,
Why
the
isn't that
statute...
why isn't that being presented to Judge Genden at a show cause hearing? That's what a show cause hearing is for, isn't it?
We have attempted to appear before Judge Genden, and he will not let her talk. He will not let witnesses talk. He would not let me talk. I mean...
Well, that was an appearance by phone, right?
I'm in Texas, and that was the reason it was by phone. It was on an urgent basis. She contacted me on the weekend. It was for our Friday, and on Monday was the hearing.
Well, aren't you asking me to tell Judge Genden that he's not entitled to even have a hearing to...
No. I'm asking you to just enjoin the arrest, and Judge Genden has been subject to 2 motions to disqualify. I would think that we've put enough on the record to establish that there's an extremely hostile relationship. I mean, there's no, this is a court of continuing jurisdiction, which essentially means that Barbara's never going to see her mother again, and she's going to get arrested. I mean, he's in retaliation mode. It's not about having a legitimate hearing where evidence is introduced against her and she's given a chance to defend herself.
So you're asking me to essentially rule in advance that Judge Genden is not capable of having a hearing? He's asking for a show cause hearing. Ms. Stone's refusing to appear, and you're asking me to say that I know, based on what you're representing, that he can't be fair, therefore he can't have his own hearings?
No, I'm not asking you that. But the statute states that he's supposed to refer it to the Supreme Court, the Chief Justice, and they're supposed to pick somebody. But he's not following procedures in any area of law. That's the problem. When you have a lack of following the procedures, you have a lack of due process. And so what I feel that we've produced enough evidence today is to show you that she's not going to get due process.
But specifically on the issue of recusal, didn't she take a writ to the 3rd DCA?
We took a writ. We did. It was denied without more explanation.
It's going on appeal.
All right, so it's gone from Judge Genden to the 3rd DCA. It went to the Supreme Court as well?
It went to the Supreme Court, and then it was sent down to the 3rd DCA.
Okay, and they ruled?
Yes.
So you're essentially asking me to sit as an appellate court reviewing a final state decision? Because
it's not a final state decision. It's a contempt proceeding. It's completely different. It should be occurring in the criminal court. It should be enjoined because it's a violation of civil rights.
Well, let's separate things, though. Specifically on the motion to disqualify. You filed the motion. It was denied. You went to the 3rd DCA. It was denied. You went to the Supreme Court. They sent it back to the 3rd DCA. So the final authority in the state system has ruled on it, right? So isn't that final?
That issue, the disqualification, I suppose that would be. We didn't appeal it back to the Supreme Court, but I'm not asking you to take a state court case. These are federal claims. Even if we had the same facts, she has federal claims, and they're under 1983, and they're for deprivation of rights. And she's been arrested 3 times. I mean, we've established that these orders on their face, now I'm happy to submit them. You can see from the orders on their face that due process is not occurring. She's testified that she's not been given due process. She's not had hearings on these injunctions against her, and then she's jailed for violating it. I mean, I think we've established 3 times. I mean, do we need to be arrested more? Is that, I don't know how we get to the point where we establish a civil rights deprivation if we can't say that we have a pretty good idea that there's enough hostility and animosity of Judge Genden towards my client that she's going to be arrested immediately. And there's nothing she can do about it because he's the final arbiter of fact. He's the final arbiter, and it's a court of continuing jurisdiction, so she can never get out of its jurisdiction. It's scary.
Okay. Thank you. Mr. Glantz?
You didn't hear what he said. Be
There
quiet.
is zero likelihood of success on the merits to the extent Ms. Barbara Stone asserts the rights of Helen Stone, because Barbara Stone does not have standing or capacity.
Okay.
So the rights, her own rights, yes, she has standing and capacity, but no likelihood of success in the merits. I've explained in writing there are very narrow, well-defined circumstances where a federal court can rule on matters that have been addressed by state courts. None of them exist here. This court cannot sit in review of Judge Genden's orders, but even an appellate court that can review works with a complete record, not bits and pieces of what one party or non-party witnesses recall. The best evidence, even if these hearings were relevant, well, you know what, they're not relevant, so I don't have to talk about it. Whatever took place in the state court is committed to that court. There's no freestanding federal cause of action that's been plausibly pleaded, and the standard for pleadings is plausibility, as the Supreme Court says. So the court either must not act due to a lack of jurisdiction or should not act either because the reasons that outlined matters of issue preclusion, the Anti-Injunction Act, and the other grounds that I've argued in my pleadings. And in conclusion, I will just say it's unfortunate that this is a litigant who doesn't take no for an answer. The 3 district judges in this district have, on 3 occasions, in cases entangled with the same matter that was before Judge Genden, have dismissed Ms. Stone's pleadings. 2 of those judges struck them, and we're here again. Now, today, my only argument is that there is no substantial likelihood of success in the merits, nor is there irreparable injury. The Florida appellate courts are open to Ms. Stone. If she's unhappy with, if she hasn't succeeded there, or if she's unhappy, this court cannot interfere.
I'm not going to talk to you.
Okay, thank you. Mr. Lustig?
Yes, Your Honor. I join with Mr. Glantz in respect to his argument. But in addition, I would tell the court that Ms. Stone repeatedly speaks of the order of Judge Genden. What they don't speak of is not only Judge Genden's order that's outstanding for a writ of bodily attachment or a warrant. We have a criminal court judge who's issued a warrant for Ms. Stone that's outstanding. So it's not just one judge.
What's that case?
It's State of
Related
Florida
to this?
versus Stone.
Related to this case?
It's based
Yes,
on the
Your-
writ of attachment.
No, Your Honor, it's not based on the writ of attachment, and that's what it would be somewhat confusing to this court as presented, but it's not. That writ, or an AC, that was issued by Judge Brennan was due to the fact that Ms. Stone has violated her orders. So that is what's outstanding. There is a writ of bodily attachment that was issued by Judge Genden in respect to Ms. Stone not appearing for that rule to show cause hearing. That was the hearing, as the court has stated. That was the hearing that Ms. Stone was to attend to present her case as
Right.
why not. She did not show. She did not request, nor was there a motion pending to attend by phone. I was present. I will tell this court no one knew that Ms. Stone wasn't showing or that her counsel wasn't showing. No one knew that she had counsel. What happened is that there was a telephone call that came in. by Ms. Schwager. To which Ms. Schwager, it was my understanding, Ms. Schwager was asked whether she was a Florida bar attorney, and there was a question whether she said yes or no, but that's inconsequential. It was passed on to the judge and was put onto a phone conference to where there was a court reporter.
I have the transcript.
Judge Genden asked who was on the phone, and the transcript will reflect exactly what I'm stating. And Ms. Schwager says that she was on the telephone, that she was counsel for Barbara Stone, and that she had filed a motion pro hoc vici in the court, or was filing at that moment. To which I will notify this court, to this day, a motion for pro hoc vici has never been filed by Ms. Schwager in the guardianship division of the Dade County Court. Again, what proceeded is Judge Genden asked Ms. Schwager, where is Barbara Stone? She's supposed to be here. We were told on the telephone that Ms. Stone was before a federal judge. And the transcript will reflect that statement. Ms. Stone wasn't before any federal judge. But notwithstanding, Ms. Stone did get on the telephone and tell the judge that
Your
she
Honor.
was before a federal judge.
Be quiet.
At that point, Judge Genden...
Is that transcript in the record already?
The transcript is in the record.
Is it in the
and,
record? If it's in the record,
he doesn't have any
then
personal knowledge as to where,
Well, look,
where she was.
it's argument, so I'm going to allow you some leeway, but I'm not going to, whatever you say in argument, I'm not going to use as evidence.
Of course
However, if you're both referring to the transcript, is it in the record as an attachment to
Yes,
your
it is,
complaint?
Judge, yes, it is.
To the complaint? To the
Or
supplement?
maybe the TRO or the complaint,
I think
it's in the record.
maybe it may be an attachment. There were
All right.
500 pages. Maybe it's an attachment to the supplemental TRO. Your
All
Honor.
right, then you may refer
I
to
would
it,
say.
but again, I'm not going to take
Okay.
your
But
representation. through an
that's enough.
argument.
I just wanted to bring to the court's attention there was a hearing, and that was the purpose of that hearing, to which she did not show.
All right.
All right. Now, in respect to the other defendants, myself, pro se, and my client, Barbara Lapidus, as counsel has stated, the plaintiff has not met the burden that's required in order for her to get a preliminary injunction before this court. And the court started this hearing by mentioning the 3 elements that are required in which to get a preliminary injunction. Ms. Stone has not met that burden. Not only has Ms. Stone not met that burden, but in respect to myself and my client, she has not demonstrated that the complaint itself or by the testimony that she has stated a claim for which she can be granted against myself and my client. She has alleged that we are state actors. By law, we are not state actors. She hasn't proven that we were state actors. We'd have to be state actors in order to come under 42 U.S.C. 1983. She hasn't adequately alleged that. She hasn't adequately alleged that her constitutional rights nor her statutory rights have been violated. In fact, based on the testimony that she's presented, she has shown this court that they haven't been violated. In fact, the law has been followed. She did what she was supposed to do in respect to taking it to the 3rd District. She took it to the Supreme Court, on and on and on. What she didn't do is what was ordered to do. But that is up to her, and that's up to her to take up to the appropriate levels, of which she didn't. That's where the case belongs, Your Honor.
All right,
Thank you.
Any brief reply, Ms. Schwager?
Yes, please. The Dabrowski versus Pfizer case, or I guess that's how you pronounce it, I believe controls this decision. And he's, first of all, the allegation that Mr. Glantz has made that the Anti-Injunction Act applies to a 1983 claim is wrong on its face. The 1983 statute provides injunctive relief as one of the remedies. It is where Congress has specifically set forth an exception to the Anti-Injunction Act. You can't say it's barred by the Anti-Injunction Act. So, I would think Your Honor would be concerned about counsel's misrepresentation of the controlling authorities in this case and direct conflict of what the actual law is. The Dombrowski case is an exception to the Younger federal abstention doctrine. And in that case, the court said that a chilling effect of a wrongful prosecution would have on the First Amendment, because what is in the record is that Ms. Stone, essentially published, and she's been sued for defamation 3 or 4 times, so I suppose Mr. Lustig can't deny that's a concern. There's motions to strike. The motions to strike are because of the language of the privileged documents. It is a speech issue. It's also a due process issue. That she's not getting due process. I don't know where he's getting the idea that if you sign an order, which is illegal to begin with, the January 2015 order, which violated Texas Code of Criminal Procedure 3.840.
Texas?
No, I'm sorry, Texas. I'm from Texas, Florida. Code of Criminal Procedure 3.840. If you have the order itself is not valid, then how can you say that violating that order is contempt? It's a void order. A void order is a nullity. It's a setup. Essentially, it was a setup to deny her the right to go seek relief anywhere. So you can't come to probate court, and now we're going to fix it where you can't go to federal court either. Ms. Stone is not a litigator. She filed some pleadings that, I guess she did her best. I don't know. But her goal, she's not suing them for damages in this case. They may not like it that she's suing them, but she's just asking for protection. She's asking for protection from 3 orders, which is the January 2015 order, the show cause order, which never should have happened, and the writ of attachment. If Judge Genden wants to proceed with something else after this, there is other relief that we've asked for, but I'm certain it's up to you whether you grant any other additional relief. And I'm not asking you to enjoin the guardianship case or anything of that nature. Just these orders.
All right, let me thank both sides for a good presentation on behalf of your clients. Let me 2 things that are somewhat housekeeping. First, you both referred to a transcript a moment ago and represented that it's in the record somewhere. I'm going to ask my clerk, Trevor, to stay behind for a minute if you can locate that, so that if I do want to look at it, I don't have to go through everything that's been filed, but we can go right to it. Second thing, this is for you, Ms. Schwager. You have local counsel here, right? And I thought that part of the system here with local counsel, and you've been admitted pro hac vice, but I thought the deal was that when there is local counsel should be doing the filing on our CMECF system. And yet, I've heard that either you or Ms. Stone have been coming to court to file things, even brought something by my chambers at one point. That's not the way it's supposed to be working. So, whatever happened in the past is the past, but if you're filing anything in this case, unless it's the very limited type of document that has to be filed in person, and in that case it's got to have your signature on it. And I don't want to keep getting emergency motions because you've yet to comply with any of the emergency proceedings. So in the future, whatever you file, that's what you have Ms. Slobodnik for. I assume that she is part of the ECF network, and she can e-file for you, and that's what the system is designed to do, all right?
Thank you.
All right. Anything else?
If I may, just for housekeeping purposes, do we need to respond? There was a pleading that was just filed recently.
Been a lot of that going around.
Yes. I apologize. I just came back. I've been out of town for 5 days and was inundated with all of this.
The most recent one?
There was a recent one.
Beat the horse some more.
And I wanted to know if the response was necessary to the extent that we've now had this hearing. There was an emergency supplemental motion to grant second amended temporary restraining order filed on June the 19th.
Yeah, I've read that, and I think we've covered all of those issues here today, so neither side has to respond to that. There was an amended motion regarding, or a new motion, I guess a response, just filed a motion to dismiss complaint, but that's not before me today. So no, the emergency supplemental motion that was filed on, I think, the 19th, you do not need to respond to that.
Which is marked as 27.
Yeah.
Thank you.
All right, no response necessary. All right, second. one other question? You want me to get into that now? All right, this is something that I haven't had a chance to look at yet, but Ms. Schwager, apparently in your response to the motion to dismiss, there's an indication that you're planning on filing an amended complaint. Is that so? And if so, is that going to moot all of our issues regarding the motions to dismiss? And you know you can't do it without leave, right?
Yes.
And you can't do it as part of a response. It has to be a separate motion. What is it, your intention to seek leave to file an amended complaint?
Yes, sir. I'm going to take some claims out and just add one claim, I think. Mr. Lustig had represented that I didn't put conspiracy in my petition to make a private person, which I don't believe they are private people because they're court appointed, but liable. And it was in the first paragraph and all through the whole pleading. And the rules 12B1 says that if, I believe it's 12B1, the rules state that if the facts give notice that it's not something that should be dismissed over. So I would ask for the time to, and I'm going to file a motion.
All right, I just wanted to make sure that you didn't, it's not appropriately raised in a response. So if you're asking for relief, you need to do it by separate motion. And again, I hope to see that as an ECF filing, not dropped off by a Chambers door.
If I may, Your Honor, just one question. I'm not quite sure, was Rule 7.1 ever complied with?
Which one is that?
In respect to the plaintiff giving this court related cases?
Yes, we have an affidavit.
I believe as a part, it might be part of the emergency supplemental motion, but it was a more recent response that included a list, although I think Ms. Schwager's position is they didn't do it because they don't consider them related, but she did give a list, I believe, of the previous cases in front of Judge Scola, Judge Williams, Judge Leonard.
Because she had responded in the last pleading, that in fact, that there weren't any related cases.
No, I don't think that's what it says. I think it says that the case hasn't been considered on the merits. It's been dismissed on the pleadings.
Well, look, Ms. Schwager, you failed to comply with a lot of things. You failed to comply with the rules for designating something as an emergency motion. You failed to comply with the rules for requesting a TRO, which led us to treating this as a request for preliminary injunction. And in my view, you failed to comply with the rule that requires you to tell us about related cases. I believe that you've now made efforts to basically make up for that. And there is a list in the most recent pleading, Mr. Lustig, I believe, that references those cases. I'm putting you on notice that if there are any others, you need to tell me about them. And if you're not sure whether they're related, let me figure that out. All right? All right, court's in recess. I'll get an R&R out as soon as I can. Thank you.
All right.